Good evening, everyone. The hour of 7 p.m. has arrived, so I'm welcoming you to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. My name is Charles Smith, and I'm the chairman of the board. This board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Inta Malice to my immediate right, Judy Freshman to my immediate left, Paul Melnick to my far right, and Peter Owen to my far left. Also present are professional staff, including Stephen Rissy, coordinator for the BZA, Clifton Hogan, assistant to the zoning administrator, Mark Hamela, whose title is zoning technician, Jaquay McNeil, administrative technician, Pamela Banner, administrative specialist, and Stephen Rissy, who is the coordinator of the Board of Zoning Appeals and also serves as our secretary. Thank you all for being here, and I want to extend a warm welcome. Now, to avoid disruptions, I ask that you turn your cell phones off or put them in a silent mode. Now, on the front table, you'll notice a series of board reports, staff reports actually, and there's one report for each of the cases which are before us tonight. If you've not had a chance to see the staff report for your particular case, or if you have an interest in viewing it, please come up and take a look at it at any time, but return it to the table so that others who might have an interest in seeing the staff report can review it also. Now, this board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance, which is adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations as they're set forth in the ordinance. That authority rests solely with the county board. This board does have the authority to do 3 things. We can approve use permits to allow modifications of placement requirements for structures on 1 and 2 family lots where there's no option in the zoning ordinance to allow such modifications. 2, we can grant variances from specific requirements of the zoning ordinance. And 3, we can decide appeals of decisions of the zoning administrator. Tonight, we have several variance applications, and we have a number of use permits, but we don't have any appeals of appeals of decisions of the zoning administrator. Now, when approving use permits, the Board of Zoning Appeals may impose conditions that we deem necessary and in the public interest, including limiting the duration of the use permit. And in order to approve a use permit, the law requires that we find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plan and land use and zoning related policies of the county. To do this, we shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria: that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or that the granting of the variance would alleviate a hardship by granting a reasonable modification to a property or improvements thereon requested by or on behalf of a person with a disability, and the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant. And that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area. And that the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance, and that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property. And lastly, that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. When deciding appeals of the zoning administrator, we must simply use our judgment to determine if the administrator was correct. Now, this evening, cases will be called and a brief staff report will be given. Following that, the board members will ask any questions of staff that we may have. Next, applicants or their representatives will be given an opportunity to make comments to support the application or appeal. If you choose to make a comment, you must come forward to the podium so your comments can be recorded. Next, all speakers for an item will be called. Speakers must fill out a speaker slip, and blanks are available in this box at my extreme far right at the edge of the dais. And after we hear from those speaker slips should be turned in before the item is called. Now, after we hear for speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points if that's necessary. The board may ask questions of any speakers, but does not permit, and we won't condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, and we've deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient time. After the board has gathered all the information we need and discussed the case, we'll decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from decisions of this board must be made to the circuit court in accordance with state law. After your case is heard, you're welcome to stay for the duration. Tonight's docket is about 13 cases, and that may take us well into the evening. Or you may leave following your individual case. The choice is yours. Again, thank you all for being here, and if there are no further items, I'm going to ask the secretary to call the first case. Case number
V-11467-19-VA-2 is a variance request by Michael and Lena Anderson, the owners, for after-the-fact approval to permit a main building footprint of 3,444 square feet instead of 3,136 square feet as required, and to permit a main building footprint coverage of 29.3% instead of 28% as required, regarding previous construction of a non-conforming replacement rear raised deck in the R8 zoning district on the premise known as 2901 North Kensington Street. Staff recommends that the board adopt the attached proposed resolution approving the variance with conditions.
Are there any questions of Mr. Rissy? Hearing none. Michael or Lena Anderson?
Michael's here.
Welcome.
Thank you very much.
Do you have anything to add? Or would you like
Am
to
I
make a statement?
hot here? Can I? Yes. Thanks for allowing me to come back. I have reviewed the staff report and I am in concurrence with their analysis. Also like to highlight 2 items. I have invested the time and effort and funding to have the proposed redesign of the deck gone through an engineering analysis and a plan, and I have submitted a new building permit application, so that is in the system. And I just learned that the zoning side, excuse me, will review this based on the outcome today. The other item I would like to highlight is that code enforcement has been very active this summer, unfortunately, posting big placards on my property. And based on the fact that we didn't have an outcome at the last BZA, they are now going to take this case forward potentially to the court unless a variance is granted today and I can get the building permit approved shortly. So that's kind of the state of affairs from my side. Except for that, the variance request stands as previously written.
Thank you very much. Questions of the applicant? Hearing none, I'd be
Mr.
happy
Chairman?
to entertain a motion. Mr. Owen.
Chairman, at the last hearing, we asked a question about whether or not a rear deck of some size could be accommodated by right, that is, without a variance, if there were if a front porch were to come into existence. And there was some discussion that that might be possible to do potentially easily if columns were added to what's already there. And I'm wondering if that was an option that you investigated.
Correct. That is the option we have investigated, and that's where we still arrive at the request of 1.3% variance. It still arrives at 29.3 with the reduced size of the deck. So that is the outcome. We weren't really clear on the numbers. We went back through the original numbers and reviewed those again, and that's where I jointly with staff arrived at these numbers.
Oh, I see.
Yeah.
I see now on this front of the staff report, the highlighted box is the main building footprint coverage with front porch.
Correct.
And previously you were in the other category.
Correct.
Okay. So you've done that.
Yes.
And now there's still a little bit extra.
Correct.
Can you talk about why that little extra is still needed in order to accomplish what you are trying to do?
Well, here's my take on it, and hopefully staff can help me out here as well. So previously, the covered entry was not part of the main building footprint. Now, when we had columns and converted to a front porch, that area will be included in the main building footprint. So it's kind of not a catch-22, but this is kind of the outcome. I think the main takeaway that I would mention is that we are now reducing the overage from previously 4% down to 1.3 in this application. So I think that is the significance of the change from my perspective.
I guess my question is, did you also explore a further reduction of the size of the deck in addition to the changes in the front?
Did not. This was what I viewed as the reasonable reduction to do to have good functionality. And I also aesthetically, it is sort of in line with the main building structure. So it looks aesthetically much better this way. So.
All right. It sounds like Mr. Rissy would also like to chime in, Mr. Chairman.
Yes, I believe I answered the original question in the staff report. There's no ability for any deck as a by right option with or without the porch. Even in both categories, even without a deck, the structure itself is already over the main building footprint. So there's no ability. So even if it was removed entirely altogether, the structure itself would still be over the main building footprint.
Yeah, thanks for clarifying that. That was one of the conclusions too.
Structure? Main building itself.
Yes.
Can you provide some numbers, just roughly?
What's the square footage of the main building with no deck?
It says 3444 instead of 1316, second line.
Right, I'm saying that, but, one is the porch is contributing, and also the main building is contributing, right?
What's the square footage of the front porch and main building with no deck?
Do you happen to have that spreadsheet on you?
Let me see. I may have it.
While we're looking at that, Mr. Melnick,
Can you make sure the speaker's mic is on?
is there a red light at your mics? Can you see a red light?
I cannot, but
The push button on the front of the microphone at the base of the mic?
Mr. Smith, his doesn't have a red light, but the microphone is on.
Okay.
microphone's on, yeah.
Okay,
It's
thanks.
a matter of how
I
close
just
it
say
is.
the timer's not on.
I guess if you can make sure you speak.
If I may answer the question that Ms. Malice asked, I believe the main building footprint with no front porch and no deck is 3,136.67 square feet.
Say that again.
I
3,000?
have the main building footprint with no front porch and no deck as 3,136.67 square feet.
And so that's 0.67 square feet over the limit without the front porch
Without the front porch
or the back deck.
or the back deck.
for,
In the table here, there's a couple of numbers that are highlighted in yellow,
Yes.
and it just happens to be that it's 3136. Is that the actual, that's not the code?
That is the code requirement for a main building with a front porch.
It just happens to be the same number as the main building.
Almost exactly.
Without the front porch in his case.
Yes.
I mean, it seems
that's
not.
quite a
not-
coincidence.
It's exactly the same number.
Almost.
Because
Not
the building
almost.
was
Half, no, there was a point something at the
Oh,
end.
a point something.
0.67, it's
Oh.
0.67 over, but I think that that 3136 limit was adopted many years after the house was built.
Yes.
So it's like they picked this house as the sample.
Is the poster
target.
child? I mean, that is credible.
At the time the house was built, there was no main building footprint coverage. There was only the 56% lot coverage for the site in total, including the main building footprint and the driveway. So they would have never calculated that number when the house was built.
What's the do you know off the top of your head the square footage of the rear deck that you're proposing?
184 square feet is what I'm proposing, which is almost a 40% reduction of the existing deck.
So
Well,
that,
actually, yeah, correct.
so the difference then is the porch, the front porch,
Which would seem to be
which would be about
34?
120.
I have 190.4.
I'm getting 344,
You guys have better math than me.
48.
And I may be
184?
fractionally off. I'm using, I think, the spreadsheet that I developed, which is a
Yeah, I
couple
did
feet
not
different than yours.
have the spreadsheet in my file here.
Any further questions of the applicant?
No.
But I do have a question about staff and,
Go ahead, please.
not about staff, for staff.
Ms. Mellis?
In your conclusion, you use the word hardship and give a rationale that it's a hardship because the conditions existed before changes to the zoning ordinance were made? Is that consistent with the law that governs variances? In other words, are you using hardship in the sort of the colloquial sense rather than the legal sense?
I don't believe we are. I think this is consistent with the requirements set forth by the state code, as the state code does mention not just the physical lot, but the improvements thereon. And they say at the enactment of the zoning ordinance, in this case, the zoning ordinance was enacted in 1950, our current one, but it allowed for 56% lot coverage at the time the house was built.
So, but if that's the case, anything that came before us that it had an improvement that was built before the zoning ordinance would be acceptable, whether it was torn down and rebuilt? And
Well,
Not
not if it
necessarily.
was torn down.
see, well, in this case, it was torn down. This deck was torn down.
No, but the whole structure.
Right. So I don't, this is apart from whether or not I would vote to support this. I'm troubled with the whereas clause that lays this out as a hardship, because I'm not sure if that's consistent.
If I may offer some, hopefully, explanation or clarification, it's a bit more nuanced than just because it was built before the changes to the, in 2005 to lot coverage. In this case, it was built in such a way before those changes that they never had the ability to add or even a smaller deck here. Because the house was over regardless, they don't have the ability to, like you had asked him to investigate, put a smaller deck on that would allow for just the connection to be made from the doors that are already in place. So I think it's not quite as simple as saying, yes, it was built before. Also, there's some analysis in there that at the time the changes were made, staff estimated that the vast majority of houses in Arlington at that time would not be affected by the changes. And so this would be in the minority of those that would be stuck in this situation where they were left with no options.
Mr. Chairman.
Did that answer your question, Ms. Miles?
So, from my standpoint, and I'm quite sure the applicant probably doesn't care which whereas clauses are included here, as long as, as long as it's favorable to him. He's not interested in our rationale. So I'm more interested, this is an internal matter I'm discussing, as to being more comfortable with understanding, because it also is in the next whereas clause. Which is true.
Well, yeah, the second one deals with simply the fact that he acquired it in
Right.
good faith.
But that again, it reinforces that it's a hardship. And
That
again,
pre-existed, yeah, when he acquired it.
Yeah. So
But the prior one, the main one is is describing how the hardship was created because it existed upon the effective date of the ordinance. That's what you're taking issue with, which I wholly understand.
Mr. Chair.
Mr. Owen, and then Mr. Melnick. I'm
See,
sorry.
I feel like this works in tandem with another part of the state law for variances, which is the general and recurring, not so general and recurring.
Right.
And staff has indicated that about 90% of houses in Arlington wouldn't be like this house, but as many as 10% would.
that's pretty
And so the question is, should we expect potentially as many as 10% of all homes to come get a variance if they are similarly situated? And that's what we have to evaluate potentially is 10% so general or recurring that it's not an appropriate action for the BZA to have a line out the door as long as 10% of the houses in the county. Now, perhaps there's further rationales that will bring us down below that 10%. That was a maximum. Staff is estimating it would be no more than 10%, I guess. But they haven't evaluated how much less. Mr. Rissy has just articulated that maybe for some they'd have to reduce their deck, but that this one has to eliminate it. Maybe this one is so low that it includes just the main building footprint with no outer decks and so forth and so on. But we had a lengthy conversation with another applicant earlier this year where we, wouldn't say yes until they promised to rip up their driveway in a future year. And we haven't even explored with this applicant whether or not they could fit, with other. We talked about the front porch and some progress was made there in terms of being informed. I will also say that it is a shame that we didn't get to ask the question about the front porch until we were in the hearing last time. I continue to be very frustrated with the fact that we can't ask these questions in advance and we don't have a structure that allows that. I think it's very inconvenient for applicants to have to get to the board meeting and then we're asking these very technical questions that they're unable to prepare for in advance. And so now I kind of wish we could have asked in advance, what about the driveway? What's the engineering of the driveway? And now we faced with potentially another deferral just to get that question answered. Anyway, the point is 10% to me seems like a lot to qualify as not so general or recurring that it wouldn't be amenable to a zoning ordinance. I think we've talked before that aging decks in the county is probably something that has hundreds, if not thousands, of recurrences. And if we say every property where the main building is non-conforming as of the most recent coverage requirement, we have to figure out how big their new deck should be. I'm not sure that meets the statute. And so for that reason, I think it is possible to have a super unique non-conforming. I think we're specifically instructed, I think, in the statute to consider existing structures. So, for example, if there was a historic cabin that they had to build around, right, that, to me, that would be a structure that maybe would be so unusual that is a structure that was, made non-conforming. But this doesn't seem like the kind of overtaking by the zoning ordinance that is so unusual that it's not capable of further zoning amendments by the county board.
Again, we have the authority to approve this, regardless of what rationale we use.
We must not approve something if it would be so general or recurring as to be amenable to a zoning ordinance.
That's true.
Any further, Mr. Melnick?
Okay, so, yeah, I fully agree with Ms. Malice in reference to what she was saying, because right off the bat, I was bothered by the hardship language too. I was thinking that would frustrate the purpose of the ordinance, that, if something is too big and then, that, like a deck needs to be replaced, that's a hardship automatically. It just seems like every case would be a hardship. So I appreciate the explanation of, how it's not quite that blunt, an issue. But I think, like Mr. Owen said, we have to be extremely careful, and that's a great way that the different parts of the ordinance or that the state law intertwine. And I too, really, I don't think that something could be as much as 10% or something that just happens to be violating the statute just because it is really a hardship. And so just like from the beginning on this case, I would hone in on unreasonably restrict the use, because I've thought that all along, just due to all the circumstances. So that's what I'd hang my hat on in this case, and continuing to support it.
Mr. Chairman?
Mr. Owen?
I'm curious if I may ask Mr. Melnick, how do you feel on the not so general or recurring prong?
Oh, I think that this, up, around 10% as we're reading here, I think that's definitely can be considered general and recurring.
And my reading of the statute is that is not merely a constraint on the hardship prong, but also a constraint on the reasonableness prong. Is that also how you read the statute?
Well, but I think, it doesn't, I don't, it's a good point, but I'm just thinking in this case, it's such that there are other factors that I'd, figure in, under the reasonableness that I think would overcome, the standard that you're referring to, the general recurring, because I think in this case that its uniqueness makes it not so general recurring. But I still think just on its own, I don't consider it under the hardship standard.
Understood. I don't feel I've yet been presented with the factor that makes this unique and non-recurring compared to other similarly situated properties. I'm not saying that it couldn't be true. I'm just saying I don't think I've heard anything yet or anyone has specified what's so different about this than the other 10%.
I think it's just, well, if I could, Mr. Chair, for me, it's just the design of the house, with all the doors, just being so integrally a part of the main house.
Yeah.
That's what makes it unique to me.
Well, I think that's helpful to have on the record.
Mm-hmm.
Any further questions? I'm going to take a different tact. I don't think 10% is of so general or recurring, and I liken that to a hitter who's batting 100. He's not looked upon as a threat. So I think that the threshold would be higher for to make it practicable for the county board to change the ordinance for those properties which might number 10% of those in Arlington that would be affected by coverage changes since 2005. I just don't think that's... And my question is, would those be those who are seeking to make modifications to their structures that would put them over the coverage limits? That, again, is a smaller number than the 10% that were cited as having that may fall into that category, then what is the subset of that who would be seeking possibly? I just think it's a relatively small number. I'm thinking more like 30% is general and recurring. You're gonna see it every other couple of times. This you're gonna see once in a while. So I would be happy to entertain a motion one way or the other, and if it's for deferral to answer the question, I can understand the issue with the hardship based on that predicate that it was existed upon the effective date of the zoning ordinance. I like Mr. Melnick's take a little bit better because that's kind of the one that I generally go to first. Is it an unreasonable restriction on the end that they would have to amounting to a hardship, and that would where you have it bedded already in concrete, the supports for the deck. I think that would be a considerable hardship. So, any further discussion? I'll entertain a motion. I think Ms. Freshman wants to make a motion.
I move the Board of Zoning Appeals adopt the attached proposed resolution approving the variance V-1167-19-VA2.
It's been moved by Ms. Freshman, seconded by Mr. Melnick to approve the variance application. Any further discussion?
Mr. Chair?
Ms. Malice.
I seek unanimous consent to omit the second whereas clause.
Is there any opposition?
It's on the other page.
You're talking about
The hardship. No.
whereas the BZA finds that the property was acquired in good faith and the hardship.
No,
The
the one
first
before it.
The second overall. Yeah.
Yes.
Whereas the granting of would alleviate a hardship due to a physical condition relating to the property or improvements thereon.
That's okay with me.
There unanimous consent?
Mr. Chair,
Mr. Melnick?
wouldn't we need then to see if there's a disjunctive between the hardship or the unreasonably restrict? So I think we have to put it whereas.
So would you accept that, Ms. Malice, to substitute where the hardship due to a unreasonable restriction?
What is your issue?
Because you have to either have that one or that one.
You have to read what, yes, I would.
Mr. Melnick, I don't think your microphone was on.
Yeah, your mic's not on.
That we would substitute that.
And let me read that language from the opening that I give. The strict application of the ordinance would unreasonably restrict the utilization of the property.
Yes.
So,
So I'm asking unanimous consent to replace the second whereas with the language
unreasonably restrict.
would restrict application of the terms of the ordinance and strict application of the terms of the ordinance would unreasonably restrict utilization of the property.
Is there unanimous consent to make that change in the proposed resolution?
Yes.
Yeah.
Okay. So ordered.
Okay.
There's been a motion made and it's been seconded. We've just amended the first whereas. Any further discussion?
Second whereas.
The second whereas. Thank you. I consider that first one kind of a
I know,
headache.
I know.
But yes, it's the second whereas. Any further discussion? No further discussion. All in favor of the motion to adopt the variance application signify by saying aye.
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 All opposed?
No.
Let the record reflect The vote was 4-1 in favor. Thank you very much. Thank you all for your attention to this matter and the diligence in your having come back, Mr. Anderson.
Well, thank you to the board very much for your attention to the matter, and a special thanks to staff who spent considerable time and supporting me on this matter. Thank you so much.
Please call the next case.
Mr. Smith, before I call the next case, I believe we have an interpreter in the audience, and I'm wondering,
Case?
yes,
That's
if they
fine.
need to set anything up before we get started.
Yes, I would like to start. Yes, sir.
Can we, Mr. Rissy, would you also ask the interpreters fill out a speaker slip and just label it as interpreter for the applicant? In court, we would swear the interpreter, but that's not necessary.
I was wondering if you could do that.
We'll just to have it in the record is good enough. We'll be a little bit more lenient with the time restriction also, given the fact that interpretation needs to be made. Welcome. Buenas noches.
Thank you.
De nada. You can explain to her that the first thing is that there's a report made by staff,
Shall I call the case?
and so he's going to call the case. And
I'll go
that will
ahead
be
and call the
dis-
case now.
And then there'll be an opportunity after we ask questions
Le vamos a tener la oportunidad de hacerle preguntas a usted una vez que se presente el caso.
for the applicant to make any comments.
Puede hacer los comentarios que usted guste.
All right.
Okay, that's
Case,
fine.
Thank you.
Case number V-11485-19-VA-2 is a request by Fred and Eugenia Torres, the owners, to permit a main building footprint of 2,411 square feet instead of 2,380 square feet.
Now take a pause,
Thank you.
and then
As permitted
watch
for,
the interpreter while you're doing that, so he can make sure that he's keeping up.
as
Thank you.
permitted for a one-family dwelling in the R5 zoning district,
En 30 áreas de metros.
and to permit a total lot coverage of 50.78%
7.6%,
instead of 45%,
el 45%
as permitted for a one-family dwelling in the R5 zoning district.
en el distrito como para cada una de las. Ese es el caso en sí.
Regarding after-the-fact approval
Todas las aprobaciones después del hecho,
for unpermitted work and additions not built in accordance
que no se haya construido conforme a
with the approved building permits
la aprobación de los permisos
in the R5 zoning district,
y como se presenta en el distrito,
premise known as
que se conoce como
848 South Glebe Road.
en la calle donde está. Glebe Road.
Staff recommends that the board
Personal le recomienda a la Junta
adopt the attached proposed resolution
y la aprobación, la solución o la resolución
approving the main building footprint of 2,411 square feet
253 pies, que es la cantidad que está aquí,
and denying the lot coverage of 50.78%.
3.6% también.
A proposed alternative resolution
Como una alternativa y resolución,
has been provided
tal como se ha proveído,
should the board see fit to approve the variance as advertised.
pueda aprobar tal discrepancia.
And you told him the recommendation.
Recomendación.
Correct.
Okay, thank you very much. Any questions of Mr. Rissy?
Mr. Chairman,
Let me start with Ms. Malice and then you, Mr. Owen.
Después pregunta usted.
I found this very difficult to follow.
Es muy difícil entender todo esto.
Do you have a timeline in terms of what events happened when in this process?
Todo el proceso.
I take it that
Supongo que
there's a current use permit,
hay un permiso que se
or a
establece
current building
actualmente.
permit
Correct?
Correcto.
that was built
Que
incorrectly?
Correct.
But there was also previous construction that was not permitted.
Or post-construction, we're not clear when some of the elements were added.
So, yeah,
We'll ask.
well, we can, I guess, ask them. So the building permit that is in question now, when was that issued?
It was applied for in there are a number of different building permits.
In 2005.
There's one that was applied for, I believe it was 2004 and approved in 2005.
And then there was a
Yes.
zoning ordinance change
Correct.
in 2005.
Correct.
Okay.
Slightly after this permit.
And this is the permit that's we're talking about right now? It's 10 years old or 15 years old?
I believe that permit was for the porches on the rear that set the need for this variance, yes. There's a different building permit associated with the addition that will be more at issue in the use permit.
The 2001,
Correct.
yes. Anything more? Mr. Owen? I'm going to Mr. Milne.
Well, following up on Ms. Malice's questions, what was the date that the 45% total lot coverage restriction was placed on R5 properties?
I know that it was discussed at the November county board hearing. I don't have the date in November of that.
No, sometime in November.
November of 2005, though.
We may need that.
Can you look up the date that it went into effect, please?
If a
The
building
record show
permit,
I asked Cliff Hogan to ask for the actual date. Thank you.
it seems potentially material. If the building permit was issued prior to the change in zoning ordinance, but the structure was built after, sorry, let me start that sentence again. If the building permit was issued prior to the change in zoning ordinance, but the structure was built after the change, but pursuant to the permit, would the structure qualify as non-conforming?
Yes.
So the permit didn't vest the rights to the property, the building of the property?
No, the building permit would have vested those rights. It's not even if the building permit was issued before the change. If the applicants applied for a building permit before the changes were put into effect, they were evaluated and approved under the prior zoning ordinance, which, if approved, would essentially vest that entitlement on their property up to the 56% that had been allowed when they applied.
Even though they built it after the
Even
change?
though they built it after.
Mr. Milne, anything more, Mr. Owen?
Yes.
Go ahead.
Do the property owners, no, that's a question for the applicant. Do historic satellite images offer any insight as to which structures were constructed before or after the date of the zoning ordinance change?
I reviewed some satellite imagery, and I just had a hard time as there's quite a bit of vegetation on the property, making a lot of the finer details are hard to see.
Can you provide those images to the board so that we can evaluate them?
Not at the hearing tonight.
Okay. Can you provide us with a copy of the 2001 variance?
Yes, I can. I'd ask Cliff Hogan to help me make some copies. I have the file here in the bucket.
Depending on how much else is missing, I'm not sure that racing to do this particular one is a good use of staff time. I didn't ask you to produce it. I asked you if you could produce it.
Yes, we can produce it.
Okay. Can you provide us copies of the building permits and applications that are applicable to these structures?
The building permit applicable to the
Structures at issue.
are some of the attachments that the applicants have provided in this report.
Yeah, are they all there?
I believe both the 2001 drawings and the 2005 drawings are both in the report. They may not, 2005 may be the only one in the variance, but I think they might both be in, no, they're both in the variance, yes.
Okay. For zoning purposes, is the front of this building on Glebe Road or 9th Street?
For zoning purposes, the front of the property is on 9th Street South.
Okay. So where is the front porch?
The front porch would be the porch facing 9th Street South.
What is its square footage?
I'm sorry, I can't discern the square footage from the plans that I have in front of me. It
What-
is less than 60 square feet, however.
Okay, that was one of my other questions. Thank you. What other porches exist?
There are porches on the side that are facing Glebe Road, and there's a porch on the rear of the property as well.
So on the north side?
That would be the north side, the rear.
Yeah, going toward the A Street side.
On the north, east, and south sides of the property.
Well, the south side is the front porch.
Correct. So front, rear, and side.
How many porches total?
3,
At least 3.
north, south, and east.
Thank you.
3 porches. So one off of 9th, one off of Glebe,
And one
In the
in
back.
the back.
and one in the back. Okay. What are their square footages?
I cannot give the square footages for each porch from the drawings provided.
Okay.
They're smaller than the front porch, it looks like from the drawing. It looks like the north one is almost a stoop, an elevated stoop. The eastern one looks a little bit bigger.
Mr. Chair, which drawings
Malice.
should we be looking at? Because
I
there's a lot of
don't, I'm,
drawings here.
yeah, I was looking at the plat that's dated 12/14/2018, and that looks to be like then the next page looks to be a blow-up of the same thing, but just a section. Yeah, I was looking at that. And then the next page looks to be a blow-up.
Mr. Rissy, is the December 14 plat represent how the house looks today?
That is my understanding.
With the improvements that were made in
Up.
2005?
Inclusive of all the improvements up until today is my understanding.
So after 2005, was there another building permit?
I am unaware of any building permits after 2005.
So how did we get here today?
That's my question.
There is a building permit from 2000, it's either 1 or 5 that has not been closed out, that ISD Inspections has reached out to the applicants, and they are going through their process to try and close that work out and finalize that building permit.
What wasn't the result of a complaint?
Huh.
I
So
wanted to know how
that's
we
like
got it.
15 years ago?
That's ridiculous.
Yes.
So this came to the county's, this whole situation came to the county's attention because
Housekeeping?
they were going through old permits to close them out?
I can't verify that. I only know the process when it came to zoning.
But you know it wasn't a complaint.
I have no complaints on record at this time.
Yeah, and some of the outbuildings that we were talking, that are alluded to, let me not interrupt. More, Mr. Owen, more questions?
I have a lot, so I don't mind being interrupted.
There's a shed on the northwest corner that I presume still exists.
que sigue existiendo.
Then it looks like there's a shed on the eastern side,
Parte este.
Eastern side, okay. That's
next to that bump out.
north. Oh, yeah, okay.
I don't know what, it says there's a ramp.
That's been removed.
Okay, the ramp doesn't exist anymore. We'll get to, I appreciate that. The pergola, that's a structure.
That's
What-
still there.
That's still there.
Can you
There's-
show a picture of the pergola? Because I was confused as to what it was referring to.
I don't believe we
I don't
have-
think you can see it. The
No.
trees obscure this pretty
Yes.
well. You have to get up into it.
Is the pergola the large structure supported in part by an oven at the corner of Glebe and 9th? Behind those bushes there? Behind that green sign?
Right there, on the corner,
Kind of to the right.
a la derecha.
Because near the
Cerca de
street number, there's a sort of a metal archway that's uncovered. But behind the trees, behind the green sign, there's a covered structure,
hay una estructura
or at least it looked covered to me. It looked like it had a roof. Is that what we're referring to as the pergola?
Esa es la pérgola.
Yes.
Yes.
The one supported in part by an oven?
By an oven?
Outdoor oven.
Yep.
Okay.
So
Right
I
on the corner.
I got it. So I would have thought of that as more like a gazebo, because a gazebo has a
Yeah, pergola is-
rainproof roof, whereas
Right,
a
exactly.
pergola has a permeable roof.
Right.
So, and there is a permeable roofed structure nearby, so that was confusing me. Okay. Where was I? The main building footprint proposed for approval is 2411, but on page 2 of the staff report, the existing main building footprint is reported to be 2380. No expansions of the main building appear to be proposed. What's the reason for the discrepancy between the 2411 and the 2380 figures?
We had a pretty difficult time in determining a main building footprint for this structure. And I'm sure the discrepancy came from different attempts at trying to calculate the entire coverage.
Okay. So, sitting here today, what would you say is the square footage of the main building?
Sitting here today, I'm glad that we at least put the larger number in the advertisement,
Okay.
up to 2,400.
Repeat what you said, Mr. Rissy.
So we've had trouble calculating the coverages for this site. There's a lot of things going into it. So the discrepancy is most likely from two different attempts at calculating the main building footprint coverage. Mr. Owen asked what I would say it is today, and I would say that it is best described as up to 2,411 square feet. And I'm thankful that that's the one that we advertised, being larger.
Okay.
But if the main building is 21 square feet less, it would be conforming, right? As to square footage.
Correct.
That's kind of important.
Yeah, that's a big distinction.
Well, I think that you're right. I think that the 2380 that we put in the portion there is the allowed, not the actual. I think the actual is 2411. This is again a situation where they are not much over the allowed, but are in a situation where they cannot expand to come into conformity.
2380 is in your table.
Yes, so that's
That's, so
probably
this
where
is
we
just a
got it
typo.
from.
Well, he said that that's a result of two efforts
Oh.
to determine, and they're just in opposite.
Well, then it would be a huge coincidence again that they're the same number.
I would say that it is much more likely that the case is that we pulled what it is supposed to be rather than what it is in this case for that second page of the staff report.
That, otherwise it would happen twice.
Yes. One coincidence I'm okay with. Two is stretching it in two cases, nonetheless.
If the staff recommendation is approved, that is to approve the main building footprint as it exists, but to allow only 45% total lot coverage instead of 50.78% lot coverage, what are the applicant's options for reducing lot coverage below that amount?
From a staff perspective, the applicant's option is to remove any elements that are counting towards the total lot coverage. That can be anything associated with the main building, any structures that are not connected to the main building that are over 150 square feet, or any portion of the driveway that is being counted towards total lot coverage.
What are the square footages of the two driveways?
Based on staff's analysis, the driveway facing 9th Street South that is being counted towards the total lot coverage has a coverage of 502 square feet and ends at the 0.6 foot concrete block wall that you see on the west side of the structure. The driveway,
You're saying it's up to the concrete block wall
correct,
and not behind that?
correct.
Is it paved behind that?
It is.
Okay, go ahead. I'm sorry. I just wanted to clarify that.
And the second driveway that is contributing to the total lot coverage is the driveway off South Glebe Road. Staff calculated its size at 713 square feet, and that goes up to the marks for the fence that intersect with the covered open porch on the east side of the structure.
What are the other structures besides the driveways? Well, what's the square footage of the gazebo?
Mr. Owen?
Yes.
Could I just ask a quick question before you continue?
Yep.
Was it staff's intention that we figure out what was going to go in our motion?
No.
Okay.
No, I'm just trying to get us, I mean,
I understand what you're doing.
To see what the possibilities.
yeah, I mean, with the very last application, we wound up, the BZA wound up making its decision based on raw reasonableness. And so what they have to jettison, do they have to saw their gazebo in half or not, or can they just get rid of a shed?
No, I'm completely on
Yeah.
board with you. It was just a factual question. Was there an expectation that we would decide tonight what had to go?
No.
Okay.
Although later we might ask the applicant what they would do.
Yeah.
Mr. Chair.
Because there is a use permit as well.
Yes, if we got that far.
Mr. Chair. So
Mr. Melnick?
I think that if it came down, and I understand about just seeing if there are other possibilities that are, easily considered, but I definitely, like if it just looks like there's lots of square footage that can be taken off, reduced, amended, that we defer and just let the applicant try to figure out exactly what's going to happen. But I understand, it seems to me the purpose here is just to bring up the fact that there may be, easy fixes, relatively easy.
If I may answer that question,
Mr. Rissy?
staff has had this application for much longer than the typical application. If you look at the application date, it was back in January of this year. Staff has met with the applicants a couple of times to try and identify quick fixes. And there are a few items that they have agreed to remove that you will not notice in either of these reports, including that ramp that was mentioned. That's one of the things they said they could remove. There's a shed close to Glebe Road that they said would be removed. We've identified and they've agreed to some of the easy fixes already, and they've asked to come forward at this time with everything else.
So if we visited and saw what's there, what we see isn't, there's less that's being applied for than is currently on the site.
I can't say whether those things are done already tonight, or they will be doing it with the other changes that may be necessary as a part of this process.
Well, I guess I'll suspend for a moment this line of questioning, but I think I would feel uncomfortable making a decision tonight until I saw a list of what those items are and what each of their square footages are in order to be able to evaluate the reasonableness question. So I'll just put that out there. if we don't make a decision tonight, then I don't need to have the whole list right now, right? Are there any pending zoning or code enforcement actions related to this property?
My understanding is that code is continuing in their process, and I believe they may have even set a court date for this case, waiting until after tonight to try and see if there was a resolution to it. The applicants may be better able to answer that question, however.
Just, may I follow up?
Ms. Malice?
Just on that point, because the previous applicant also mentioned a court situation. A BZA deferral, does that slow down the court situation?
Absolutely.
But
Both.
it didn't for him, it sounded like, or,
Well, it slows down in that code and the applicant both have to go to court and ask for a deferral to set a new court date. It does not automatically stay enforcement for code is the issue here. It will stay enforcement for zoning only.
Mr. Owens?
I'll pause on my questions for now.
Ms. Freshman?
My original question, I think, has been answered because I wondered how we even got here. If it was a complaint, apparently not. And I agree with other comments that have been made that this is incredibly confusing. It's confusing just when you go to the property and look at it. And now the fact that there's been some discussion of some things on the property that might be removed, which appear to me to mean some of the numbers we're looking at aren't useful. I mean, they might be useful as a starting point, but if they've agreed to take some things out, but we don't exactly know how that changes the numbers, to me it screams deferral. And probably for a couple of months until everybody gets their act together and figures out what they're going to remove, and if it's even possible for them to get within compliance.
Yeah. I concur with that. Ms. Malice?
And of course, for both the variance and the use permit.
I concur as well. The lot coverage number here is based on existing, not what would happen after some of these structures went away.
No, it's with the structures. Most of the structures that they have agreed to remove do not impact the lot coverage because they are less than 150
Less than 100
square feet.
each.
Okay.
They have more to do with the use permit than the coverage in this case. The only structure on the site that is not attached to the main building that is over 150 square feet is what is labeled as the pergola on the 2018 plat, and that is one that they have not agreed to remove to this point.
So what's driving the coverage here?
The
Main
very
building?
large main building footprint, 2 driveways,
That,
and that pergola.
so that's an area that we would also focus on what can be done to bring coverage down. So that would be a question for the applicant to think about in a deferral period of, those 2 driveways and how that coverage would come down.
Yeah, I would like to see also really much better, actually, some photographs of the pergola itself. And hopefully the applicant would let staff on site to get some better pictures of what exists. It's fairly easy to see the driveway, the 2 driveways, but it's impossible. I couldn't discern the pergola. Yeah, so generally there's a form that an applicant is given to sign to authorize that. Was that prepared, Mr. Rissy?
It was.
Okay,
Before we move on,
yeah.
comments.
Any more questions of staff before I ask the applicant to come forward? Okay, hearing none. Thank you for your patience. while we discussed with staff some of our questions.
algunas de las preguntas que teníamos.
Now this is an opportunity for you to make a statement,
Alguna declaración.
and also after that, if you want, we'll have to ask more questions.
Tenemos más preguntas para ustedes.
So,
Ahora,
welcome.
Estamos de acuerdo en reducir lo que hay que reducir, ¿no?
so we're in agreement to remove the things that we have to, so we can have the final inspection approved by all of you.
So let me, that's their presentation in general?
Su presentación general probablemente es esto. Yes, it's just about the final inspection that we're
Okay.
waiting for.
We have questions about the size of things that are there right now. So we're on the verge of asking you to defer this, and we'll take action to defer this a couple of months so that we get more information, pictures of what's all there, and also for you to consider whether you would be willing to reduce, for example, the size of one or both of the driveways, or the pergola, the outdoor structure, and any others. We're kind of confused right now. I'm sure you are too, with what's going on. It's a very complex kind of a situation that you have.
Mr. Chairman,
Mr. Owen.
if I did my calculator right, it looks like your by right coverage is 45% of your property for all the buildings. That's the amount allowed by law with no action from the board. And your main house is less than that. So if I used my calculator right, and this isn't official, it looks like you have about 982 square feet left in addition to the house to build other things, as long as they're in the right place. Without us needing to approve it at all in this variance step, in the first step of the two things we're doing tonight, because that would keep it under 45%. Your application currently asks for more than 45%. It asks for 51%. So even more than 982 square feet. And so we will be interested whenever we decide the variance. Why do you need even more than 982 square feet? Why isn't 982 square feet enough? But if 982 square feet is enough, then you might not have to ask for us to take action at all.
El primer problema que teníamos era cuando hicimos la ampliación
The first issue is that when we did the first construction,
de la cocina, que hicimos una ampliación que salió 2 inches.
the kitchen has about 2 inches off of its own.
Por eso no nos pasaron.
Since it has 2 inches, or it is 2 inches bigger, that's the reason why it was not approved.
Which kitchen?
That was the 2001
That's the first one in
bump out.
2001.
That alcove
When we did
area,
when we did the second one,
like this part was added on.
to build on the upstairs or the addition that we had to do, we also filed all the documents that you asked for, and it was approved. So when we wanted to complete the whole inspection of the entire house, we were told that the first one hasn't been approved
2 inches.
for those 2 inches. That is the reason why we have been waiting all this time.
We have different things to consider.
Tenemos otras cosas por considerar también.
This board only deals with a small part
Solamente hay una parte muy pequeña
of the conversations you've been having with staff.
de las conversaciones que han tenido con los del personal.
We are required by law to ask some very specific questions
Muy específicas,
that are only a small part of all of that long conversation.
pequeñas, de las conversaciones que hemos tenido.
And so even though it's understandable
Aun y cuando es entendible,
that one thing led to another,
a otra, después a otra,
and we're working on something that is 14 years old,
y ya tiene 14 años de
a
antigüedad,
construction project 14 years old,
14 años de antigüedad,
and that's all very difficult and complicated.
difícil para verlo.
We have to decide whether or not
Hemos decidido todavía
the law allows
y
you
les permite a ustedes,
to have your driveway plus your house
aparte de la
plus
casa y
the
más
other
aparte,
structures
otras
all be
estructuras
more
que
than
tienen
45% or not.
más de 45% de cobertura.
And we have very specific rules about how we should
Específico de cómo
evaluate
están
that.
las casas, de la forma como hay que evaluarlo.
And so the next, if you come on another day,
We're willing to make a reduction of all that you're asking.
You don't know what we're asking.
Yeah, that's good.
Qué
that's
bueno.
good. That would make it easier.
Va a ser
But,
mucho más
but
fácil para
before you
todos.
say yes,
Pero antes de que digan sí,
measure your driveways,
midan sus
measure
entradas,
your
midan
gazebo,
el gazebo también.
contract the jackhammer,
Como también
ask him how
contratar
much the jackhammer costs,
les va a costar contratarlo.
and make sure you can really go that low with your driveways and your other buildings.
Con todo lo que tienen ahí construido. Okay.
But, and let me add, it's not your fault right now that we don't understand.
Que no entendemos
It's just
nosotros.
very confusing.
Simplemente muy confuso.
A lot of pieces.
And there, there are even questions about whether some things existed before 2005 or after 2005.
Después de 2005.
Was the pergola
La pérgola
built after
fue construida
2005?
después de 2005.
Before.
¿Fue
Okay.
antes? It was before.
Okay.
I meant to say
But the
after.
driveway, it looks like your
It was
driveway,
after. Una de las entradas.
the driveway on Glebe Road
En la calle
looks like it's new or newer.
nuevo, ¿no? Se ve más nuevecito.
It was redone.
Right. It's when we did the second addition. It was done after the second, during the second addition.
That brings up another point, Mr. Chairman.
Aquí,
Mr. Owen.
eso nos lleva a otro punto.
Any evidence you have in writing,
Pruebas que tengan por escrito
Or
ustedes,
neighbors who can testify
cualquier vecino que pueda declarar
about what was built before November 2005
de noviembre de 2005,
or what was built after November 2005,
que se construyó después de 2005,
including the driveway,
incluyendo
including
las
the
entradas,
gazebo,
las entradas,
including the
el
house,
gazebo, la
including
casa,
the different parts of the
las
house.
diferentes partes de su misma
The written records that you may have
expedientes que
that
tengan
show
por
which
escrito,
pieces were built before 2005
lo que se ocurrió antes de
could be very
2005
useful to our decision.
puede ser muy útil para
Like
nuestro
receipts from a concrete contractor
un contratista.
for when they poured that they, maybe you have a file of all of that somewhere, maybe not.
Or even family photographs.
Yeah, because I think it was gravel before.
If you had a party and
That's
the
right,
party
that's
was in
right.
2003 and it shows it, that would be an example.
Okay.
Years. I used to live right around the corner.
Just
Ms. Malice?
couple, for staff, is there a material difference if we call this pergola versus gazebo?
I think pergolas are mentioned in the zoning ordinance as having certain characteristics. I'm not sure whether it matters for a variance versus a use permit.
I believe pergolas and gazebos are grouped together in the lot coverage in chapter 3, but Mr. Owen's going to reference.
It may not matter. Mainly I asked because I was confused.
Yeah, I just
I was
want to make
looking
sure
for a
that-
pergola.
I mean, they're not a garage which has specific rights. They're an accessory structure.
It is an accessory structure that is not an accessory building, which is the key point. Regardless of whether it's a pergola or gazebo, it is an accessory structure that is not a building.
Or a fireplace, a fire pit.
Okay.
Structure, not a building.
Which we'll discuss later on.
That will come up.
Okay, one more question for staff. Yes. In the subject, it says RE after the fact approval for unpermitted work.
Sorry, could you repeat that?
That's in your, the subject line of the staff report?
Yes.
The last phrase, RE after the fact approval for unpermitted work. Is there an after the fact approval that we're making?
Well, yes, it would be,
If it's granted, all the buildings that are going to be here.
you would be sanctioning the work that is there
Would be an
currently.
after the fact approval of all the buildings. And nothing else could be built here after that.
If you are granting them coverage over the allowed amount, they would not have the ability to add to that unless they came back to this board.
Mr. Chairman, if we defer this, I would be interested in potentially making a list of what documents would be helpful to have the next time.
And incorporated in the motion to defer. That's what I presume you're, something that's going to advise both staff and us of what is the purpose for the deferral.
I think maybe the motion would be general, to obtain more documentation and information for the board from staff and from the applicant.
Such as, I would want to try to list some of those main things that we want.
I'd prefer to just put them in the record and not the motion.
Or you would ask for, okay, I want them enunciated somewhere so that, we're kind of clear. I know I've seen from the minutes in the past where we've done deferrals and asked for specific things, and that's been very helpful.
Yep.
To refresh recollections, certainly mine at least.
Yep, I agree.
We-
Mr. Chairman, may I propose that we, trying to think of the word, I'll wait for the translator.
Yeah, that's fine.
Mr. Chairman, we haven't yet held the hearing on the use permit.
Correct.
And there's a different list of documents we might want for that one. And there might be some overlap. So I would move that we defer consideration of this item in order to hear the next item. And then return to this for a motion and vote after hearing the second item.
I mean, that's a little clunky, but that's fine. I think that having some discussion of the use permit and what is needed to answer any questions that arise from it, I think is helpful. Certainly doing the motion, the action on the variance can be deferred to have discussion of the next item.
Yep. I'm just saying, if we were to start right now to do a motion for deferral, should we do it to November? Should we do it to January? We don't know because we don't know how involved the use permit will be.
And I just want to be clear on what action, not January, February, we have a work session
right.
in January, but what, I'm not clear, I heard something about code enforcement, and I know zoning enforcement would be stayed until actions before the BZA are completed, but code enforcement, I think you said, would not.
Correct.
So they would have to go to court and ask the judge to defer based on an administrative process that's going on, which may obviate the need to be in court.
They may elect to do that, or they could elect to go through the court case.
And fight the code enforcement case. Yeah, well, I presume they have counsel, but that would be something they would entertain.
Mr. Chairman,
Mr. Owen?
can I just ask the applicant, do you have a lawyer who's helping you with any part of this?
No.
Have you considered hiring a lawyer to help you with any part of this?
Do we need to?
you're not required to, but many people before us do hire lawyers, especially when they have a complicated case.
Yeah.
But it's not required.
But let me add, if you are also facing a code enforcement action, we're not asking you or telling you that you should have a lawyer, but personally, I would if I were in your shoes. But in any event, let me ask unanimous consent to defer further discussion of the variance and ask the staff to call the next item, which is the use permit for the same property, so that we can have some discussion of it before we get too far along. So hearing no opposition, Mr. Rissy, would you call the associated use permit?
Case number V-11485-19-UP-1 is a use permit request by Fred Nugila Torres, the owners, to permit setback relief for several building and structures to include, number 1, 2 open porches, 14 feet, 13 feet to the porch eaves from the South Glebe Road right-of-way, instead of 21 feet to the porch, 19.5 feet to the porch eaves, as required. 2, the wall of an addition, 11.6 feet, 10.6 feet to the eave, from the South Glebe Road right-of-way, instead of 12 feet, as previously approved by the BZA. 3, a pergola 8.5 feet from the South Glebe Road right-of-way, and 2.5 feet from the 9th Street South right-of-way, instead of 25 feet as required. 4, a shed 2.5 feet from the South Glebe Road right-of-way, instead of 25 feet as required. 5, bay window bump outs 23 feet from the 9th Street South right-of-way, instead of 25 feet as required. 6, a window well 20.5 feet from the 9th Street South right-of-way, instead of 21 feet as required. 7, an open porch 19 feet, 18 feet to the porch eaves from the 9th Street South right-of-way, instead of 21 feet, 19.5 feet to the porch eaves as required. 8, a pergola 2.5 feet from the 9th Street South right-of-way, instead of 25 feet as required. 9, a rear porch 7 feet from the rear property line, instead of 10 feet as required. 10, a shed 0.9 feet from the rear property line, instead of 10 feet as required. And to permit plantings, a structure, pergola, and fence between a height of 3 feet and a height of 10 feet above the level of the curve within the visual clearance zone as required by the Arlington County Zoning Ordinance, Section 3.2.6A4, regarding after-the-fact approval for unpermitted work and additions not built in accordance with the approved building permits in the R5 zoning district, premise known as 848 South Glebe. Staff recommends that the board adopt the attached proposed resolution granting approval to permit setback relief for several buildings and structures to include 1, 2 open porches, 14 feet, 13 feet to the porch eaves from the South Glebe Road right-of-way, instead of 21 feet to the porch, 19.5 feet to the porch eaves as required. 2, wall of the addition 11.6 feet, 10.6 feet to the eaves from the South Glebe Road right-of-way, instead of 12 feet as previously approved by the BZA. 3, a pergola 8.5 feet from the South Glebe Road and 2.5 feet from 9th Street South, instead of 25 feet as required. 5, a bay window bump outs 23 feet from the 9th Street South right-of-way, instead of 25 feet as required. 6, a window well 20.5 feet from the 9th Street South right-of-way, instead of 21 feet as required. 7, an open porch 19 feet, 18 feet to the porch eave from the 9th Street South right-of-way, instead of 21 feet, 19.5 feet to the porch eave as required. 9, a rear porch 9 feet from the rear property line instead of 10 feet is required. And 9, 4, a shed 2.5 feet from the South Glebe Road right-of-way instead of 25 feet is required. 8, a pergola 2.5 feet from the 9th Street South right-of-way instead of 25 feet is required. 10, a shed 0.9 feet from the rear property line instead of 10 feet is required. And to permit plantings, structure, and pergola and fence between a height of 3 feet and a height of 10 feet above the level of the curb within the visual clearance zone as required by the Arlington County Zoning Ordinance, Section 3.2.6A4, with the conditions stated. An alternative proposed resolution has been provided, should the BZA see fit to approve the application as advertised.
Mr. Chairman?
First, I think Ms. Freshman indicated a desire to ask a question first, and then I'll go to you, Mr. Owen.
Well, I just want to make a general observation, having listened to the actual subject and recommendation of the use permit, that our previous conversation of saying that to the extent that we can have any documentation, whether it's receipts or photographs or permits or anything that would help clarify, I think they'd be equally useful for both the variance and the use permit.
Agreed. Mr. Owen?
Mr. Chairman, I'm unclear about whether the staff is recommending, what the staff is recommending with regard to the 25-foot triangle. It appears
Denial.
Deny, okay. Because the word permit appears most proximate in the resolution and in the staff recommendation.
I tried to break it up into those we approved, being everything after approved, and those being that which we thought
Got
should
it.
be
But
denied.
the staff recommendation is don't put that stuff in the 25-foot triangle.
Correct.
Okay. Thank you for that clarification.
Ms. Malice?
Just, how did there's some features here of the house that are requesting relief, bump outs for windows and stuff. How did that get in the mix?
The error, was that
An
in general
error?
the error in the building? Instead of 12 feet, it's 11 and a half?
The bay window bump outs, but because it's
That's
on the
one of
night, it's on the right-of-way side, not the back.
No, that's on Glebe Road, but that's the side yard.
There are some window wells that staff couldn't account for building permits for the construction of. The bay windows, I believe, may have had construction, but were shown to be at a distance that was approvable. And I believe the porches fall into that category as well.
So they weren't built as permitted.
Correct.
They were built bigger than permitted.
Slightly closer.
Okay.
But some things weren't permitted at all, like the pergola.
That is staff's understanding.
Yeah, that we don't know.
Anything more to add to our list of wants from the applicant in light of the need to defer?
Mr. Chairman?
Mr. Owen?
So I'll just say that I think it would be, if this, I'm sorry if this is a repetition, but I think it would be helpful to have a map of the site.
Yep.
With all of the things that are built on the site.
Yep.
And for all of the things that are built on the site, it doesn't have to be an architecturally precise, engineering precise document, but a map, a sketched map of the site that shows every structure, what's known about its age, what's known about its size,
Yes.
what's known about its placement.
Yep.
That includes the driveways, that includes the main building, that includes the porches as separate elements of the main building, sheds, ovens, pergolas, gazebos,
And a partridge in a pear.
all those things, so that we can see what the universe is. And what we've learned from the applicant also is that we would want to know which have been identified by the applicant as something they intend to remove, and which have been identified by the applicant as things that they are hoping to retain. And that way we can figure out what the difference is.
Thank you very much, Mr. Owen. That's helpful. Ms. Freshman.
Well, I agree with all that, but I'm looking at what appears to be a plat,
This is the
which
97 one.
is from 97. And we've had people come in recently who had to do after-the-fact approvals for inches
All right.
because old plats are not necessarily accurate.
All right.
If we had a survey, it would accomplish a lot of things,
That would.
That's true.
not the least of which is all the stuff that's there and what's legal. Oh, yes.
There is the December 14th, 2018 survey included in the packet that should accomplish, I believe, what you're asking for.
Okay, I'll try to
It
find it.
doesn't have
I don't,
distances.
it doesn't, I mean, the pergola is not really well identified, or gazebo. And then it doesn't have that distance. I mean,
The
it's,
shed doesn't have a distance.
So you're talking about this one?
Correct.
yeah.
Okay. I stand corrected. Well, maybe somebody could at least measure and mark on this because it's faint and
Yeah.
not
Yep.
complete.
And
Yeah, I mean, it should be annotated as to what is, because you mentioned two things, the ramp, or the applicant did, the ramp and the shed closest to South Glebe being things that they had no trouble removing whatsoever. That would be, I would like to see what Mr. Owen and what Ms. Freshman just described as, with annotations. I know that the sheds, I can't tell the dimensions of the one in the corner on the western side, the northwestern side, but nevertheless, I just don't think this is clear enough. And photographs. Personally, I would like to see photographs of, this pergola / gazebo / outdoor kitchen.
And good.
Yeah,
And what's
yeah,
intended
what
to be
they would propose that was removable.
I agree. In general, I think part of what we're struggling with is that a lot of the use permit and the plats and so forth, the writing is so small in this 8.5 by 11 photocopy format that it wasn't apparent to us what we have and what it means and what the date is on the document and all that sort of thing. So I think even for the stuff that we have, clearer labeling could help. But I don't mean that to detract from the need to have something like what Ms. Freshman pointed out, blown up to a bigger
And
size,
annotated.
with more clearly annotated.
Yeah, I mean, you have this one window well, which looks like it's penciled, the dimensions are penciled in 45 inches by 48.
Or 51.
And then what are the dimension, what's the dimension between that window well and the lot line to 9th Street? It's, but anyway, I would, I think, benefit from seeing something a bit clearer. Ms. Malice?
If it would be possible to set up some kind of identification, this is shed A, shed B, specifically in whatever the motion to adopt is. If we're going to get into that detail. Yes, so that we can say, so in the motion, we can be very clear as to which, I know we're describing it as the shed on the lot line or on Glebe, but if we could just give it a specific coding or name or something so that we're very clear in the motion.
And you did it, you're numbering each of these elements, and then, yes, very helpful, and then what you would agree to, what you recommend granting, and what you, differentiating those, that was ideal, that was very good, that was good foresight.
Mr. Chairman,
Yeah.
yeah,
Mr.
different.
Yeah,
Yes.
the applicants just mentioned that they removed 2 of the sheds.
Yeah.
Okay.
So we need to see.
Yeah, that was mentioned. What we're going to ask them to do is to come up with a better drawing, actually, and a surveyor would be able to provide you with that, with all the dimensions between all the structures, and then photographs. And we're asking staff to come out to your property and take more photographs of of the things we can't see behind the tree, for example, the trees.
Mr. Chairman,
Mr. Owen?
just to further follow up on the question I asked earlier, in this use permit part of the application, would the 25-foot triangle include parts of what we're calling the pergola?
Correct.
All right.
That's
so
just so the applicant knows, we're talking about the corner of 9th and Glebe. The code requires visual sight lines on those kinds of corners, and there may be an issue with what you have built there in the sight line.
well, there is an issue,
Yeah.
and the question is how to resolve the issue.
Yeah.
And so
We can remove the trees as well, or the bushes.
So it may be that even if on the variance, the part 1, even if you had room in your 942 square feet to keep the pergola, it might be it has to go away anyway because of the triangle for 25 feet. So that's an example of the different parts being in play. Mr. Chairman,
I'd be happy
I
to-
have a variety of other things I'd want to ask staff to think about during a deferral period that most of them are not related to the applicant, but they relate to what could be in the staff report. I wonder if it might be the time to run through them quickly.
Go ahead, please, so he can make note of them. And we're going to hopefully move to the motion.
Yep. I thought that there were some challenges to the comparison table for street setbacks on other nearby parcels. Several of them are not actually nearby. And I did think that the one on 6th Street was an important comparison, and the next door property is obviously an important comparison. But for example, the South Randolph setback is from a hillside pedestrian stairway and not from an arterial street like Glebe Road. The one on 9th Street is from a dead-end street, again, rather than an arterial street. And when I went by to check the comparison at 4001 9th Street South, unless I went to the wrong property or misunderstood what I was looking at, I did not actually see enclosed porches. So the properties that I think are the most important to compare with are the ones that immediately surround the property, and probably also corner lots along Glebe Road that are in that R5 zone. So there's maybe 8 corners or so, maybe 8 to 16 corners, and those are the ones that are, within sight of the property and have similar conditions and might make the best comparison. And then actually, Mr. Chairman, I realized that there is one that I would want to direct to the applicant, which is that the BZA usually prefers to have more written feedback that you get from your neighbors, including the neighbors across the street in all directions. So that would be, for example, all the houses on your corner, the one on the, across the street, in each of the 3 directions across the street, as well as both of your next door neighbors. Right now, there's one that we have across the street, and we have one next door neighbor, but that still leaves 3 or 4 more neighbors that we would want you to talk to and get something in writing from them that says, what do they think about all this?
In fact, you should have gotten a handout or this is a new handout. We'll make sure you get this from staff. It describes just what Mr. Owen was saying. It's a new document that we've developed.
But thank you for getting the two that you got. That was helpful. And we just need a couple more. Yeah, I think I had some questions about the phrasing of the resolution, and I think it probably would be
Use permit?
for the use permit resolution, yeah. And I don't feel like I want to take up everybody's time tonight with that, but I'm frustrated because, again, once we conclude the hearing, I feel like until we reconvene on this item, we may not be allowed to talk about that again.
Well, we won't be able to converse with the applicant, but you certainly can, you can ask staff
No, we've been advised I cannot do that.
for materials.
But I can't say, I'm confused about this phrasing of your proposed resolution.
Yeah, no, you can't.
Well, that's, I mean,
I can't-
their
I can't even
drafting
s-
of the resolution is
I can't even say forward
that's
this
really
email,
a
please.
secretarial function. We're
I-
dictating, in essence, we're dictating what we want in a resolution.
I was advised that I'm not even allowed to say, please forward this email to the applicant.
No, it wouldn't involve any communication with the applicant whatsoever.
I understand. I thought that's what would cure it, right? The problem is ex parte communications related to the matter.
Except, we relate to staff right now in terms of just dictating the resolution, making amendments to the resolution.
I used to
Then they produce our minutes.
I used to think that until I got a letter from someone saying I specifically wasn't allowed to do that.
Not that. The letter didn't say that.
It did. Because what prompted it was saying, please forward this email. A purely
Yeah, but
ministerial.
you're not asking the staff to forward anything to anybody.
And the reason why it was deemed ex parte was because for that instant, before they actually did forward the email to the other party, there was an instant in between where the other party was not included in the communication.
But
All right, we're getting in the weeds.
yeah, I don't.
Anyway,
I think,
I'm going to suspend.
I think you're over.
I'm go-
I think you've taken that too far with respect to what ex parte and staff, because we can direct.
I think we should talk about this offline.
Well, that's fine too.
If it's,
But
well,
I think that if you want to have if you are proposing language for a resolution that
I'm not. I have questions about the language that's proposed, but let's talk about it offline.
well, then certainly you can probably address that in general when developing resolutions, versus talking about one related directly to a case.
Okay, we'll see how it goes. I think I'm finished.
Okay.
I'm ready to
How
make
much
some.
time do we think we should afford the applicant, Mr. Rissy, given that hopefully you're going to have some more discussion with them with respect to how to answer these questions, how to provide this information?
I am more than willing to meet the applicants between
Sure.
now and whenever date you feel is appropriate. I will mention that the advertisements for the October hearing at this point have gone and run in the
Oh,
paper
yeah.
today, so that would be too soon, but anything past that is,
I was thinking either, is December too far?
No. I would say December would be. I was thinking December or February.
Yeah, that's what I was hoping not February, but I was,
Well, we could schedule December, and if it's still not ready, we can
Right.
defer again.
yeah, no, I know. It's not that, it's the kind of the lapse in time, and
Mr. Chairman,
I'm sure the applicant wants to get this dealt with.
Mr. Chairman, I'm prepared to make a motion on both items.
Okay, let's hear it.
I'm going to offer them as two separate motions. And they're not exactly the same.
Now, this one, the first motion relates to.
The variance.
Yeah, the variance, 11-485-19 VA2.
Mr. Chairman, I move to defer the variance V-11485-19-VA2 to the December BZA meeting for the purposes of, 1, providing additional documentation to the BZA, and 2, to allow the applicant to further consider reductions in coverage by reductions in the main building and/or outbuildings, and to allow the applicant to obtain additional feedback from nearby affected neighbors. That's my motion, and if it's seconded, I'll speak to it further.
It's been moved by Mr. Owen and seconded by Ms. Freshman to delay the variance application until
December 11th, 2019.
May I ask a question?
12/11/19.
Mr. Chair.
Now discussion. First, Ms.
Just a
Malice, and then Mr.
Question on the
Melnick.
motion. I think Mr. Owen referred to buildings in his point number 2. Would you want to include driveways?
Yes. I would ask unanimous consent to include the words and/or driveways after the word buildings.
Hearing no objection, so ordered.
Mr. Chair.
Mr.
Oh,
Melnick.
how about structures like the pergola? Things like that. I don't, if you're talking about buildings, I think that'd be more of a structure.
Mr. Chairman, I ask unanimous consent to change the word buildings to structures.
Hearing no objection, so ordered.
Mr. Chairman, I'm prepared to speak further to the motion.
Go ahead, Mr. Owen.
The additional documentary evidence, I hope, would include one or more plats or schematics indicating the age, size, location, and planned modification or removal of any structures on the site. And as well, clearly labeled copies of prior variances and building permits for the site. And as another item, photographs, including satellite photographs that indicate the age of the structures. And I'll further add, that would also include photographs that you may have in your own personal photograph collection. So that's it for the variance application.
Very good.
Second.
That was seconded by Ms. Freshman already. We're in the discussion period of the motion.
I'm just
Hearing no further discussion, all in favor of the motion to defer and seek additional information and defer till December 11, 2019, signify by saying aye.
Aye.
Aye. All opposed? The ayes have it. That matter is deferred. Now let's take up the use permit.
Mr. Chairman, I am prepared to make a motion.
Mr. Owen.
Mr. Chairman, I move in case V-11485-19-VA-2. I'm sorry.
-1.
Wrong one.
-1.
-1. So V-11486.
485.
That,
485.
no, 485.
It's 485.
Sorry.
At least that's the way it's
Where am
labeled. And it's advertised.
number
It's advertised as 485 also.
Oh, here
One
we
is
go.
UP, one is VA.
Sorry. All right, in the case V-11485-19-UP-1, I move that the Board of Zoning Appeals defer the use permit application to the December 11th, 2019 BZA meeting for the purposes of providing additional documentation to the BZA and to allow the applicant to further consider reductions in coverage. I'm sorry, to further consider reductions in setbacks. And 3, to allow the applicant to obtain additional feedback from nearby affected neighbors. That's my motion. If it's seconded, I'll speak to it.
It's been moved by Mr. Owen and seconded by Ms. Freshman to defer the use permit in the instant case to December 11, 2019, and seek additional information and neighbor feedback. Any further discussion?
Mr. Chairman,
Mr. Owen.
in addition to the documentation that I specified for the variance, much of which would be applicable or easily adaptable for the use permit, I would also request additional comparisons to the setbacks on surrounding corner lots.
Yes, and that's more or less staff's function.
Staff, yep.
So you don't have to worry about, the applicant doesn't have to worry about doing that.
Correct.
Any further discussion
¿Alguna discusión
of the
adicional?
motion to defer the use permit?
La moción para
Hearing none,
diferir
all in favor of the motion as read and described, please signify by saying aye.
Aye.
Aye. All opposed? The ayes have it, and these matters are deferred until December. And so a little bit more work, and hopefully by December, we'll be able to resolve this.
y esperamos que para diciembre hayamos podido
Thank you very much.
Thank you.
Mr. Rissy, please call the next case.
Case number V-11486-19-UP-1 is a use permit request by Julia Rebecca Deloney, the owner, to permit a right side setback of 4.7 feet to the wall, 4.4 feet to the porch eve from the right side lot line instead of 8 feet to the wall, 5 feet to the eve as required, and to permit an aggregate side yard of 15.9 feet instead of 18 feet as required, regarding the replacement of an existing right side screen porch's foundation, post screen, and guardrail in the R6 zoning district on the premise known as 4609 19th Street North. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions of Mr. Rissy? Hearing none, I'll ask Mr. Ahrens, who is representing the applicant. The applicant is here and didn't need to fill out a speaker slip. They don't ever, but Mr. Ahrens, he always does. Welcome again.
Thank you. Thank you to the board and staff, as
Make sure you're
always.
speaking into that microphone.
Thank you to the board and staff, as always, for opportunity to present this. I believe Mr. Rissy has already provided a lot of information in here, and we accept the report as is and leave it open to any of you for any questions you may have.
Mr. Chairman,
Mr. Owen?
I'm prepared to make a motion.
Let me ask before that, do you have, your representative does a fine job every time. You did fill out a speaker slip. Do you have anything to add, Ms. Deloney?
Ms. Maloney, yes. Actually,
Please come to the mic.
I absolutely love this house. This porch has been there since 1935. I just want to basically replace it. And I would appreciate anything y'all can do to help me move that along. I think my neighbors will be very happy too.
Good.
Mr.
Okay.
Chairman?
Mr. Owen?
I'm prepared to make a motion.
I'd be happy to take one.
I also agree it's a lovely porch. I move that in the case V-11486-19-UP1, that the Board of Zoning Appeals approve the resolution as proposed.
Second.
It's been moved by Mr. Owen, seconded by Ms. Malice, to approve the use permit request as presented. Any further discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Aye. All opposed? The ayes have it. The matter is accepted.
Thank you to all of you.
Thank you. Thank you for
Have a
your
good evening.
patience.
Thank you.
Some cases are easier than others.
It's been a learning experience.
I'm glad someone learned something. Okay, please call the next case, Mr. Rissy.
Case number V-11487-19-UP-2 is a use permit request by Daniel and Morgan DeMotts, the owners, to permit a left side setback of 4.1 feet to the wall, 3.1 feet to the eve of a rear addition instead of 8 feet to the wall, 5 feet to the eve as required from the adjacent property line, and to permit an aggregate side setback of 15.3 feet instead of 18 feet as required, regarding a new one-story rear addition in the R6 zoning district on a corner lot on the premise known as 2164 Quebec Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. And any questions of Mr. Rissy? I just want to say, I know that wasn't your doing, but thank you for including all these photographs. That was the applicant, I'm sure. And Mr. DeMotts?
Yes, sir.
Welcome. I note that your agent has also filled out a speaker slip. You're both entitled to speak, and in whichever order you prefer.
I'll take whatever questions you want if I need to refer anything.
Well, you have anything to add? Anything you want to say in particular?
Well, basically the project is to update a 1928 kitchen that's been reduced in size by some work we had to have done in 2011. We had a foundation wall that was crumbling, and in repairing that, we had to bring the stairwell that ran alongside it up to code. The rise-over run of the 1928 stairwell was nothing close to what the code required. So the stairwell now runs about 4 feet into the kitchen. As you step into the door of the kitchen, it's so small that the refrigerator door cannot be opened fully and blocks the entrance to the kitchen as well. You can't open the dishwasher and the oven at the same time because the doors hit each other. And it's simply, I mean, it was built in 1928 with the idea that one person was going to be in it and no more than that. And it's insufficient for a modern family. Our neighbors are very much in favor of it. We've had a number of small houses on the street knocked down with large built in the past few years. We're trying to preserve the existing house, make it more livable, modernize it, and keep it as is for the next 50, 100 years as well. So we're hoping that you will all approve this.
Thank you very much. Any questions of the applicant? Mr. Melnick?
I'm prepared to make a motion.
Well, hold on
when the
just
time
a moment.
comes.
I'm going to give his architect, Sean Nazemi, an opportunity. If you'd like to add anything.
Just, they're trying to be very conformant with the rest of the neighborhood. What they're proposing is very simple and similar to the houses in the neighborhood. So seeking your approval for that. Thank you staff for the.
Thank you very much. Any questions of the applicant or his architect? Hearing none. Mr. Melnick.
Okay, so I'd like to move that the Arlington County Board of Zoning Appeals adopt the resolution granting the use permit request with the conditions as stated.
Second?
And let me say the case number, sorry. V11487119UP2.
Thank you very much. Moved by Mr. Melnick, seconded by Ms. Malice to approve the subject use permit as presented in the incident case. Any further discussion of the motion? Hearing none. All in favor of the motion signify by saying aye.
Aye.
Aye. All opposed? The ayes have it. The matter is granted. Thank you very much also for your patience. Please call the next case, Mr. Ricci.
Case number V-11488-19-UP-1 is a use permit request by Charles and Sarah Plaxico, the owners, to permit a rear setback of 6 feet to the screen porch, 5 feet to the eave from the rear property line instead of 21 feet to the porch, 19.5 feet to the eave as required, and to permit a rear setback of 3 feet to the built-in grill from the rear property line instead of 25 feet as required, regarding a new screen porch and built-in grill in the R10 zoning district on the premise known as 3505 North Jefferson Street. Staff recommends that the board adopt the attached proposed resolution denying the use permit request with conditions. An alternative proposed resolution has been provided should the board see fit to approve the application as advertised. And please note that there is supplemental material for this case that came in after the application packet was assembled and printed. It is additional clarifying information from the applicant.
Thank you very much. I do note the packet of additional materials here for case 1188. I mean 11488, 11488. Okay. Questions of Mr. Ricci? Well, hearing none, we've got, I've got speaker slips, and I'll leave it up to you. We have Thomas Fleury, Marina Turner, who is the applicant, and Sarah Riddle-Moser from Moser Architects. You're Mr.
I think you have Tom and Dorothy, our neighbors that share our back fence, and then Sarah Riddle-Moser, who is also a neighbor.
I'm sorry?
Sarah Riddle-Moser, a neighbor,
Is a
also
neighbor?
here. Is also
Not
a
the
neighbor.
architect. Okay.
She is an architect. She's
No,
a very
I know.
good one.
I know she's an
but,
architect
yeah.
also.
But she's
I
also a
know that.
neighbor. Yes.
She has appeared before us also. Okay, well, let's start with then Thomas Fury.
As the applicant.
Oh, you're the I'm sorry.
Sure.
Mr. Plaxico. Welcome.
Thank you very much. So you do have the additional packet, which is 6 bullet points.
Yeah.
Great. Okay. So first of all, thank you, and of course, Stephen, thank you very much. From the day that I came into the office saying I needed to fix something in our backyard because my wife got hit on the head with a black walnut, his team has been really supportful and helpful. So thank you. My wife, Sarah, is back there. We are here in Arlington for about 2 years, and this will be our home. We live across the street from a middle school and elementary school, so we're not planning on flipping this house. We want to be here and make these improvements. Well, I also have with me John Benson from Sun Design today. They do a lot of work in Arlington and are well respected, which is one of the reasons we selected them for this project. So I'd like to run through these 6 key points as to, we understand the staff is recommending denying it. I think we have a very unique situation and would appreciate your just consideration. So first and foremost, we have a 65-year-old maple tree that you can see. It really takes over the bottom right of this whole photo. I have additional photographs here when it's not the winter that just shows how big and immense this tree is. It's a canopy. You can see it from the cul-de-sac. It's beautiful. Of course, with the recent floods, the roots also help with erosion control. And I think if there's anything related to the tree, we want it there. We will put any language that you would require within the approval to make sure it does stay there. Again, we're building our porch with sustainable materials, hopefully, as well. So definitely that's top of mind for us. So number one, we want to preserve this tree. Number two, our lot. It's a little difficult to see, but it's pretty unique from a topographic perspective and shape. There was a question of, could we be building off on the side? We actually couldn't. There's a few reasons for that. There's an extreme downslope, and you can see this when you look at Appendix A here. It's really a deep, deep hill. And further to that, there's also a sewer for the county and easement, and I think there are setback requirements related to that. Mm-hmm. So also, if we were to build on the side, then as you're approaching the house from the cul-de-sac, you're going to see a very large jutting out addition. What we're doing now is concealing it in the back. From the front, you would not see any difference. So, we're hopeful that you can take that in consideration, because there'd just be a clear view from the street, even though we could probably do that without any approval here. Third point, we already have comparable accessories right behind us. In fact, and if you look at Appendix B, you'll see we would just be walking right out of our porch, and there's already a shed there, and that's within about 2 feet of the property line. To the left, there's a very large garage, also, again, within 2 feet of the property line, and fits right in. So no one's losing a view. All of our neighbors are very supportive here. So Appendix A and Appendix B have additional pictures. Please peruse those as I finish my final 3 points. Number 4, the porch is going to provide protection for ourselves as well as any guests for both the large black walnuts, and I'd like to show you what they look like. If you don't mind. This is what hit my wife.
Oh, my God.
And I really can't use.
I don't need one.
That's going to be difficult to find.
But
they'll accommodate it. So.
Mr. Chairman, let the record reflect that the applicant has provided each of us with a large green-colored walnut that is approximately 2.5 inches in diameter.
Yeah, larger than a golf ball, but smaller than a baseball.
Oh, they can get baseball size. This is early in the season.
We don't have any of those before us, though.
Yeah.
So
just imagine
maybe
that
we'll defer for the larger one.
Hopefully not. And then also the mosquitoes. My wife and I sat outside yesterday. Within 10 minutes, we had 9 bites. Had to go in. I think Dorothy will talk to what it's like where we are
Sounds like you might have a drainage problem.
One of the neighbors did speak to that.
Some water problems.
We could also talk to that shortly here, too. And in terms of point number 5, precedent does exist. 9 feet, 4 feet, 7 feet, accessories, much closer. There's also an address in Arlington that I found on GIS where there's an overlap. And so, I know that's probably a focus here. This wouldn't be setting precedent, in my opinion, but of course that's up to you to decide. And then, finally, our neighbors are all very supportive, 3 of them here tonight. And, I think the note from Hillary and Joe, making sure that there wouldn't be additional runoff, that's absolutely something we responded to quickly. We really like Hillary and Joe. We were just at a barbecue with them anyway. And we also switched from concrete for the back patio to permeable pavers. So we want to make sure that can do that. John, of course, at Sun Design is very aware of the drainage, and then we'll have landscaping put in as well. We actually were impacted by the recent floods based on our topography and have to redo our whole basement in the tile because it ripped up all we had a little bit of water in there. So we're very conscious of this, and again, similar to the tree, if we want to add some language that pigeonholes us into what we're doing with water, we're happy to do that too, because that's part of our plan. So with that, I don't know if we have time for John to speak on any points, or if you have any questions for me, whatever you prefer.
That is Mr.
He doesn't have a speaking slip because he's an applicant, and I thought I heard you say that he didn't need one.
Well, if you want your architect to make any comments, we'll ask him to provide a speaker slip. He can.
Sure.
He's entitled to. Well, you can do that after. You can do that after.
It's
you
just
make the
that we need,
presentation.
That's my fault.
Oh, the box is empty?
Yeah, the reason we do that
We'll
is
get more.
so that we spell the names right in the record.
Okay, you can make the presentation. Give us your name and address and the like.
Okay, my name is Jonathan Benson. I'm with Sun Design. My name is spelled Jonathan Benson.
Okay.
I'm a designer on the project. One of the drivers on the project was there's a tree there that Vince talked about that would likely be cut down. If we put the porch in that location, in the left rear of the house, you can see there's a place there that looks like a porch would go there. That's where that tree is. The arborist also explained that if they put the slab right over that tree, right up against it, it might kill the tree. So the other option was to do a porch over on the other side where it dropped off, where Vince explained. That area, actually, there's bedrooms there, so we'd have to do some rearranging of all the rooms in the house to get there. So it made sense to have the porch there where it is. The drainage we looked at, and there's a swale back behind the house that we're going to keep where it is. We're not going to touch that, and all the drainage from the house is going to go under our construction to that area. And we'll be working that as we go through. As far as the, I guess the grill wall is accessory structure, correct?
Yes.
Okay. So is a permeable patio with a 3-foot grill wall in the back, a stacked stone. And that's actually right almost behind the fence where the shed is that he talked about. I think that's everything. Also, design-wise, we want it to fit in with the house and the neighborhood. So instead of pressure-treated wood and screen, everything's wrapped, painted, up to high quality that way. Do you have any questions for me?
I have a question about the distance between the back of the addition and the grill wall. So, I mean, that looks fairly, I mean, there's a porch, and then you step off, the grill wall looks like it's a foot, 18 inches?
The height?
No, from the back of the addition.
The porch.
Yeah.
We have a step down onto the patio.
What's the distance?
Yeah, what is the distance?
Like
distance down?
Probably like 4 feet from
Is
when
it?
you step out
That's
to
not-
the grill wall, because then the grill wall
Well, I don't
is
know,
3 feet.
okay, well, this might not be to scale, because it says 1/4 inch equals 1 foot. But those are probably on an architectural drawing that was much bigger than this.
Yeah, I'm confused.
These 8.5 by 11s aren't the size of the architectural drawings.
Right.
Okay, so that scale doesn't really work.
Those are
Okay.
full-size drawings. Just
All right,
reduced.
so it's 4 feet, okay.
Yeah, so from
All right.
here to there is about 4 feet.
Correct. Mhm.
And then you got 3 here for the 7.
Yeah, I was just looking at the, one of the elevations, A21.
No,
All right.
The patio's at grade or 8 inches, no more than 8 inches off the ground.
Yeah. You're talking about the elevation of the patio itself.
Right.
And I was talking about the distance from the porch on the back to the grill
Setback's
wall.
about 4 feet, correct.
Okay.
Mr. Smith, if I may try and clarify, the floor plan A11 may be enlightening. The grill wall is fairly well separated from the proposed screen porch horizontally. There's a closer, they appear close in the elevation, but they're really probably 15 feet away from each other.
Okay.
Right, in plan view.
we're looking at
Page A21.
this plat that's got,
Well, the plat is not, I was looking at,
Yeah, they're about 15 feet from side to side.
But 4 feet coming out the door.
it's behind, the distance from the back of the porch to the grill wall looks like a narrow number.
it looked narrower than, because this is not to scale, really.
Yeah, it's about
And then
10 or
the-
15 feet one way and 4 feet
It's
the other way.
at least 7 feet, which is the depth of the proposed screen porch.
Okay, maybe it's 3 feet. And then the back lot line is the,
It's on the lot line.
is what you are seeking some relief from, and that you need, how many feet?
3 feet from the grill wall and then 6 from the porch.
3 feet to the built-in grill from the rear property line.
Correct.
Instead of 25. Okay. So if there weren't the grill wall, the back would be roughly 6 feet, the back of the porch to the rear lot line.
We have that spelled out in our application.
Correct.
Yeah. Okay. I don't have any more questions.
Mr. Chair?
Mr. Melnick?
So my thoughts, just about this case is, I appreciate, the matters that you brought up about the porch, the screen porch needing to be in the back, not on the side, and the tree. But the standard does seem pretty clear about that the proposal promotes compatibility with development with surrounding neighborhood because of the overall footprint size and placement are similar to the structures. And then it's conjunctive where it says, and would the proposal help preserve natural landform, including significant trees and foliage. But it just seems like, according to the information given by staff, this is not at all close to what's going on with the structures on the property surrounding the subject property. So just because, just that standard, having heard, what you're saying, just due to that standard that we have to abide by, it doesn't look like I could support this, on account of that. But those are my thoughts about it. I'm all for trees, but we do have a standard here. So,
Could I comment on that?
Mr. Chairman?
We'll hold your comments for a moment. Sure. Mr. Owen?
I certainly appreciate Mr. Melnick's expressed conundrum. We have sent a formal letter to the county board to ask them for clarification, either through changing the zoning ordinance or otherwise, as to how they expect us to consider the trees or foliage element of this test. And one of the things that we specifically asked about as one possible interpretation or intent of the county board was for exactly a case like this, where everybody else in the neighborhood would have to do it to put it in the middle, closer to the house, not as close to the property line, not push the envelope this way. But a countervailing consideration is, I could imagine the county board saying, in this kind of situation, nobody wants the tree to go. It's better to save the tree and have some awkwardness and what would otherwise be unallowable discontinuity in placement because you're saving the tree. I think there's a good chance that may have been the county board's intent, but maybe using unclear, inartful, or perhaps not even successful language. But I'm struggling because I do think it strikes me as quite possible that this is perhaps a really unusually good example of what they might have meant. That said, I don't see how even using that theory, we could approve this tonight unless we had much better options presented to us for how the tree would in fact be preserved. And for that matter, there's another element, which is that it wouldn't be detrimental to neighboring properties, and I don't think that's been established because there's a water runoff question that hasn't been addressed with. We have a willingness of the applicant to accept language about the tree, a willingness of the applicant to accept language about water runoff, but we don't actually have the language before us to approve, and we haven't even, I didn't even ask my question yet of staff about whether they thought there could be an enforceable condition. But even if it were possible, I think tonight is not the night where we would arrive at that. So I think from the 40,000 foot level, I feel like this is something where we could approve it, we could approve something, not tonight, but another night, that is broadly consistent with what is probably the purposes of the county board. And then the question is the language so constraining that even though that might have been their intent, they didn't write it down in a way that allows us to act on that? So that's sort of my thought process.
Let's have some more discussion after we go through these speakers. There are a few speakers listed here. Thomas Fury, 5513 Williamsburg. Welcome.
Thank you. You pronounced my name correctly, too. That's good.
You print very clearly, and thanks to the public schools.
Yeah. So I live in the house that is in the back of that photo, okay?
I'm very You live directly behind?
Directly behind.
That white cinder block garage is yours?
That you're looking at my house in that photo.
I'm sorry, sir. Could you one more time repeat your address?
It's 5513 Williamsburg Boulevard.
Thank you.
Okay, so we live directly behind Vince and Sarah, and the piece of land in question, or the place where the screen porch would be facing our house. And we fully support it because we know that with the 5-foot fence between the two of us and the shrubbery, it's not going to visually impact upon us. And we also appreciate the fact that Vince and Sarah bought the house and didn't tear it down and build a 3-story starter castle like is happening with virtually half the houses in our neighborhood. That would have been looming over our backyard. So we appreciate the fact that they are not taking steps to intrude upon, visually upon the rest of the neighbors. And I just want to support what Vince said about the biting insects. I don't think they're mosquitoes. They're what we would call in the mosquito coast of Central America, we call them no-see-ums.
Yeah.
They're just really, really tiny things. You can't even see them. And we don't have a screen porch because we had our own issues about how much land we already took. So we've only been able to sit outside 3 times this year to have a meal. So I fully understand why they would like to have a screen porch.
Thank you, Mr. Fury. Let me ask you, yours is the white cinder block garage directly?
That is correct.
Okay, thank you.
Which you can also see in the photo on the left.
Yeah.
Yep.
They've supplied us with some additional photographs that actually, I think, show your property a little clearer, too.
Great, okay.
Thank you very much.
Okay. Thank you.
Any questions of Mr. Fury? Hearing none. Marina Turner. Oh, you're on the next case? Okay. Okay. So that's 8, 9. No problem. I'll move you to the next one. And Sarah Riddle-Moser. Welcome.
Good evening, members of the board.
In your capacity as a citizen.
I am speaking as a neighbor.
As a neighbor.
I have lived in my house, which is 2 doors down from Vincent Sarah's.
What is your address?
3504 North Jefferson. So 2 doors, looking at their house to the right in the cul-de-sac. I'm very familiar with the house. We've been in our house for 5 years now. So I was friends with the previous owners before Vince and Sarah moved in. And fully support so many things, right? The keeping of the tree, the fact that they do have an impervious trellis patio built area outside of that family room on the rear currently. So in terms of impact to disturbance, I think it's the right decision to expand where they have already sort of enclosed trellis patio area. So I fully support, as a design professional, the decision and placement. They have a tough situation with the grading. I should speak as a neighbor about the runoff. That, what was it, early July downpour we had. The water rushed mostly in front of their property, actually, into a storm drain in the cul-de-sac that is in front of the neighbor directly to the right of them. I think the concern any of us would have would be structures built on steep grade. So the placement of the screen porch they have is at probably the flattest portion of their property. So as a neighbor, I have fewer concerns for sure about runoff where they have it located. So it justifies again why, the house placement puts them in a predicament. It's set really far back. I am curious though, from working a lot in the county, why staff didn't propose an adopted resolution. I understand that there was a hearing of the prior owners in 2002. I couldn't dig it up, but I assume they had to have some effort to, get relief from a 25-foot setback on the rear. So I would plead all of you, staff and the board, to, consider that, right? The house placement forced the previous owners to come forward, and needs change, right? As people buy a house, different ages, different families, different family members, needs change, and a screen porch for these guys would be really important. Thank you.
Thank you very much. That was our last speaker on this matter. Any questions of the applicant again by any of the board members?
This is where the construction is. This is not where the speaker was. And this is where the guy says he's got a water problem.
Right.
Mr. Chairman?
Mr. Owen?
Can I ask a question of staff?
Please.
Mr. Rissy, if it were the board's intention to approve this application only if there were enforceable conditions for tree preservation and for eliminating water runoff onto the property at 5519 Williamsburg Boulevard, do you believe that staff and the applicant would or would not likely be able to work out, leave the applicant out of it. Do you think that staff would, given sufficient time, be able to craft enforceable language conditions for those two items?
I don't believe staff would be able to work out enforceable language for those two conditions, as tree preservation and water runoff are two things that are not administered, overseen, managed by the zoning division.
Right.
Both of those are under the purview of DES, and so I do not believe staff could enforce the condition requiring those elements, unless there was some sort of architectural feature that you wanted to see included or not included. But even then, it would get so specific that I think that it would be difficult for the applicant or future owners of the property if we mandate that they have gutters run certain directions. If there's a stormwater treatment method in the future that eliminates the need for the gutters, it wouldn't be available to future homeowners because here's a condition stating the direction of gutters.
I'm a little surprised by that answer because we have, in fact, in prior applications, had there was a written condition to have a French drain, next to the shed. There is a tree preservation ordinance that probably this tree doesn't literally qualify for, but the ordinance has written requirements that might be copied and pasted into a condition. So I'm a little surprised based on the county's demonstrated history with similar problems having condition language, enforceable condition language, that both of them seem so hopeless.
Would you like me to elaborate or no?
Sure.
Well, there are things you mentioned, such as the tree preservation ordinance, but in staff's limited understanding, it's pretty limited because at the time of adoption, they adopted 9 trees in the county. All have to be approved by the county board for inclusion on that list. So even if the applicant did elect to include their tree, it would have to go to the county board for inclusion. I did some very...
Well, that's not what I meant.
Okay.
What I meant was, after the county board votes for inclusion, there are requirements of what the tree gets. What rights does the tree have after the board votes? Yes, you're one of those trees, right? And it's that we might be able to adapt as condition language.
Are they similar to like the historic landmark review board?
If I may add, in my, again, limited review into this, there's also worries that the county board has about takings associated with the tree preservation, to the point where they put language in there stating that the owner would be compensated for any takings that are included with trees that are included in this list on private property.
If the tree was involuntarily designated.
Yeah.
If the tree is voluntarily designated, there's no taking. Yeah, all right. Thank you for answering the question.
Well, and I have a question of the, you have a question, Ms. Malice? I'm wondering from the applicant whether you make reference to having had an arborist look at the tree. Are you, by virtue of doing that, are you saying that your intent is to preserve the tree?
For sure, 100%. And right now I'm looking up Arlington, like, champion tree status to kind of get to what Mr. Owen's talking about. Like, if it's a champion tree, then you can't mess around its roots in such an area. You can't trim it X many times a year. Like, we love this thing. We don't want to have it go.
Yeah, but it's not one of those. It's not.
I don't think, yeah, it's not that big.
You know, what Mr. Owen was asking, how can we enforce your expression of willingness to preserve it, which may be costly. There may be, you know, efforts that you have to undertake that are greater than someone would have to undertake normally without such a tree in their yard in the construction process. And we can't enforce those is the problem that it was highlighted.
And the question is, what if you have to move, you sell the house 2 years from now, and the new owner comes in and says, well, I don't want to do any of that stuff. And they start to chop limbs off or even chop the tree down entirely, then there is still a question of, well, if they chop the tree down, that's clearer. But if they mess around with the tree in an unpermitted way, then who from the county comes out and says, oh, you can't do that. You messed with the roots. Now, do they get a code violation? Do they get a zoning violation, right? That's what I was hoping staff might help us navigate. I think it's worth exploring. I mean, I guess basically, Mr. Chairman, I would be very open to a deferral for the applicant to confer with staff and possibly a land use attorney to propose for us conditions that we might find achieve the purposes of the zoning ordinance.
Like a preservation easement, maybe.
Yep.
Tree preservation easement.
Yep. Recording it with the property records would be an important element of that, so future owners would be on notice.
Mr. Rissy had his hand up.
Just a few clarifying remarks. Zoning staff is absolutely unable to manage the type of things that you're asking them to do in this situation. We do not have the expertise to evaluate tree conditions.
No, we know.
And so if it's even put in a condition, zoning staff doesn't have the ability to enforce it. And actually, on the point of including it as an easement, there was recently a case a couple months ago where the board asked an applicant to record their variance with the land records office. Land records did not accept that the variance would be recorded with them and asked us in the zoning division to please stop sending people to record things with them that they can't record.
Was that
Yeah, did they send you a writing?
Yeah,
Is there
did
an
you send
It
email?
was not in writing. I would have liked to provide that to you. There was a
Because
phone
usually
call
you
between.
can record anything. They don't look to the substance of it.
They told us they could not and would not record a variance for the applicant.
That's a ministerial act.
They're not
All
supposed to
I
look
have
into
been
Require any
told.
discretion.
Yeah.
You're supposed to do it, whether it's, I mean, they don't have any enforcement property, authority.
We should ask our council how to get this done.
Yeah, we should. Meanwhile, that's,
So there's two issues.
yeah, so that was very helpful, and obviously it's of prime concern because I'm of the opinion that the topography prevents you from going down the hill, and the tree prevents you from going back in that area. Really, what you proposed is the only area that anything to the rear can be built. Less so with the grill, but the grill wall, but certainly the screened-in area is a matter that's different, and personally, I believe it qualifies for some relief from a strict application of the ordinance. I'm going to go with Ms. Malice.
I wanted to just move on to the water issue.
Yeah, I noted at least one neighbor had indicated approval, but some concern that
it
they
is-
all share, as Ms. Riddle-Moser described.
It is the most affected neighbor. It
Right.
would be the neighbor, and I wondered if you've had any conversations with that neighbor.
We have, yeah. We emailed them and we talked to them recently about coming here to the BZA. And our first email back is absolutely, we're going to make sure the water doesn't change. And
What
as
are-
John, sorry.
So my question is, what measures are you proposing? And have you discussed them with your neighbor? Yeah, it'd be the. 3509 No, it's 50.
5519.
It's Hillary and Joe, yeah.
They say, we're supportive of your variance request, yeah, but would appreciate it if you can consider drainage water runoff as part of your construction plans.
So the question, again, similar to the tree issue, is if we were to permit this, if we were to approve this, what measures are you taking and how can we record what they are?
Did architect, I think, made some reference to that. Can you elaborate on that?
So I'm not sure if they're having problems with the water now, but we're not planning on changing the direction of the water. There's a swale back behind the property, and we're going to keep the water going where it's going now. So I'm not sure what their concern was.
So one way of skinning that particular cat is for you to present written documentation of your plans, perhaps slight revisions or elaborations on the construction plans, present them to the neighbor and obtain the neighbor's, before you come back to the BZA, obtain the neighbor's view that he is fully satisfied. And that way, those plans and elaborations can be included in the record that is then an enforceable part of the, of the use permit, right? And then we don't have to worry about extra conditions. It's inherently part of the drawings and so forth that are already referenced. So in a way, that's easier than the tree, because as long as we don't have an after, what we can't do is say, later, we promise to get the neighbor's approval. It has to be before you come to us the next time.
Is it okay if I talk? I just get really nervous.
I'm sorry.
Speaking.
I don't have the right to tell you can speak.
Yeah, of course.
But I do, and I will if I know who you are and you provide a speaker slip.
I'm Sarah
Unless you're the wife.
Plaxico, and I'm one of the applicants.
I'm sorry?
I'm Sarah Plaxico, and I'm one of the applicants. I'm his
Oh.
wife.
This is my wife. She's the one
Yeah,
that
it's your wife.
I just
Okay,
get very
you're
nervous
Sarah.
public speaking, so I was going to stay quiet, but I was hoping I could say something. So currently, our water does not run off into our neighbor's property. I did speak with them. They have a standing water issue next to their shed that they have right now. So they just wanted to make sure that there wasn't extra water pointing in that direction that was going to stand next to their shed. So there's
Right.
not a current issue
No, right.
with that. And
That's kind of what their email says.
yeah. And I know this is a little off topic as well, but we do have 100% best intentions for the tree. My husband works in solar, and we're very environmentally friendly as well. And I used to work for the Environmental and Water Resources
Yeah.
Institute. So,
So the easy fix is to get fresh written evidence from your neighbor that says that they are completely unafraid of water runoff.
Sure.
Based on your plans. So if you get that far, we can take that off the table. But with the tree, I'm not worried about you. I'm worried about if you need to move, what the person after you does, because they would have potentially, I think they're under coverage. So by right, they might be able to chop down the tree and build more on the house in that same
That's the
location.
biggest fear, that if we give you a break to build in this area because of the tree, someone comes along, cuts the tree down, and comes to us, or maybe by right, wants to put something up. And the whole, our work, well, and our efforts to accommodate your desire to build in a certain place kind of are moot at that point.
yeah. And I know it doesn't help, but we don't have any intention of moving because we're planning
Well,
to.
we were discussing requiring an easement preservation easement being recorded such that it would go with the land and no one in the future could take down that tree, for example.
Right.
I think there's a high chance that if you consulted an attorney, that
Yeah.
they could probably come up with
absolutely,
something that we would find acceptable.
And the county wouldn't be the enforcement mechanism. It would be a neighbor who would say, hey, they cut down the tree. Yes, it's after the fact. And what would be the punishment for violating a preservation easement?
The lawyer, well, see, the thing is, the lawyer would have to figure out who has standing to do
Yeah,
that.
yeah.
That's a question for their
Yeah,
lawyer.
that's a very interesting question too. Who does have standing to bring an action for a tree that's taken down on?
Because we
adjacent-
already know
But anyway.
what staff's answer is going to be when we say, is this
No, we know, we're not going that way, with no offense to
They're
the
going to
staff
say,
whatsoever.
not by us, and we don't know otherwise.
Just for clarification, as I read at the beginning, it says significant trees or foliage have to be considered. We've asked the county repeatedly for a definition, or for someone to describe to us when a tree issue occurs, what a significant tree is. And we have been unable, as staff said, it's not their responsibility to come up with someone from the county who is willing to say what's significant or not in terms of a tree. Be that as it may, we're faced with trying to make these decisions every month that preserve significant trees and foliage based on no real scientific or policy basis.
Mr. Chairman?
Mr.
I'm
Owen.
prepared to make a motion.
Let's hear the applicant first, and then I'll entertain your motion. He's got a...
Just one quick question. It seems like we
clarifying
might be here for a little bit of time tonight. Would you give us a little bit of time to talk with Hillary and Joe and connect them with John tonight? And if you get that confirmation, you're okay?
No.
And,
No, it's a little bit more than that that's needed. It can't really be ironed out tonight. I know they're carrying costs you're probably worried about, but...
If you want a decision tonight, you're entitled to one, but my guess is it will be no. If you're
Staff
willing,
has denied your application, so we have to have a good reason.
Well, they've recommended denial.
Recommended
And that's
denial,
all they've
so-
done. We don't live by their recommendations. We're independent of them. But they've done the dirty work, if you will, the grunt work, and we value their opinion. We're not bound by it, but we value it.
Appreciate that.
And in this case, there are enough questions that have come up with respect to wanting to see how water is going to be mitigated, given the terrain and the future life of the tree. That would, I think there is a majority for moving this, deferring this so that we get some of that answered and get a better drawing that describes how that's going to be, the water's going to be mitigated.
Mr. Chairman?
Mr. Owen?
I'm prepared to make a motion.
Let's hear it.
I move in case V-11488-19-UP-1 that the Board of Zoning Appeals defer this matter to the November 13th, 2019 BZA meeting for the purpose of allowing the applicant to proffer an enforceable condition for preservation of the tree, and for the applicant to provide the BZA with sufficient evidence that the proposed improvements will not adversely affect the neighbors with water runoff. That's my motion.
Is there a second?
I'll second.
Thank you. It's been seconded by Ms. Malice. And a motion made by Mr. Owen to defer this matter to, repeat that date for me.
November 13th.
November, 1 month.
2 months.
I'm sorry, that's not 1 month.
Yep.
It's too late
2
for
months,
October.
but it's too late for October. Any further discussion?
It's just, I think we ought to offer the applicant, if they would prefer to have a decision tonight, we can
Vote down that motion?
vote this down and vote on
No, I don't think that's necessary, but could we do the October meeting? We'll have
Too late.
everything you need.
It's been advertised, it's too late.
But the advertise would be unchanged in this scenario, I think.
I mean, he does make a point that they're not looking to change any of the parameters of the request. The deferral would be to provide additional information.
It's
They
standard.
do, and they now tell us that I think Mr. Rissi's going to say that it wouldn't be a problem to put it on as,
October?
yeah, on the October agenda.
There's still time for legal advertisement for October.
You can,
I mean,
if you can do it.
We'll get it done, Mr. Owen, I promise.
if someone else wants to make the request, our standard is 2 months, and we often find that we're caught behind the 8 ball and have to do multiple deferrals, or it's not fully complete, or there's something else. I mean, I think this is a very tricky operation that we're doing without the assistance of our staff, who is recommending a full-on denial. And, you know, we're under heavy scrutiny and criticism, you know, if we get this wrong. I appreciate your desire to move quickly, but I just...
In general, 2
Could
months
I-
is...
Could
2
I
months
ask,
is our
when is
standard.
the last day? Because then if we can get something in a week, and we know we're confident that we can come back here in October, then we'll do it. If not, then November makes sense. But just...
They have to set.
We're we're deferring to a specific time. We can't say, well, maybe October, but then if not, then November. That's why we set the outside parameter.
Mr. Chairman, I'm, for purposes of discussion, I'm going to vote no on this motion. But for purposes
You
of
made the
discussion,
motion.
I know, but just procedurally to move us along, for purposes of discussion, I move that we amend the motion to be the October BZA meeting instead of the November BZA meeting.
So you want to vote on an
I
amendment?
want to see if there's support for the amendment to change the date.
Got it.
Which I will vote no.
You need a second. I'll second.
Okay.
Well, yeah, you'd already seconded the motion.
No, this is a different
This is the
motion.
amendment.
So you've withdrawn, you've
No,
accepted the withdrawal?
No, I'm offering an amendment to my main motion to change
Okay.
it from November to October.
Okay.
And I'm about to vote no on it.
And you're...
Seconding his motion to amend.
Fine.
Now we're going to vote on it.
Yeah, we can, absolutely. Any further discussion on the motion to amend the first motion?
So this is the motion to move to October instead of November. All right, this is an amendment to move to October instead of November.
Yep. All in favor of the motion signify by saying aye. All opposed?
No.
Nay.
Okay, now we're back to the main motion to defer to November.
Yes.
See you guys in November?
Yes, all in favor, yep. All in favor of the motion to defer this matter to November, what is it, 14?
13.
November 13, 2019, signify by saying aye.
Aye.
And all opposed? The ayes have it. The motion described what we need. So those two things, the tree and...
You're fighting an uphill battle, but we're pushing in the same direction.
Much appreciated.
Thank you very much.
Thank you.
Mr. Rissy, please call the next case.
Case number V-11.
So thank you for the witnesses who came.
Okay, thank you.
Wait, we need one of those.
For the record.
Yeah.
For the record?
I'm going to insist the county file it. Please call the next, probably not. Please call the next case, Mr. Rissy.
Case number V-11489-19-UB-1 is a use permit request by William and Marina Turner, the owners, to permit a left side setback of 4.6 feet to the wall, 3.8 feet to the eave, and 8.4 feet to the porch instead of 10 feet to the wall and porch, 6 feet to the eave as required, and to permit a right side setback of 4.8 feet to the wall, 4 point to the eave, and 3.1 feet to the chimney instead of 10 feet as required to the wall, 6 feet to the eave, and 8 feet to the chimney as 8.5 feet to the chimney as required, and to permit an aggregate setback of 9.4 feet instead of 18 feet as required regarding front and rear additions, porch, and by right deck in the R6 zoning district premise known as 2700 First Road North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Questions of Mr. Rissy on this application? Hearing none. Now, Ms. Turner, welcome.
Thank you so much. Thank you so much, everybody, for hearing our case. The reason that we're asking for this use permit is that my husband and I love Arlington. We love our neighborhood. We love the fact that our house backs up to Long Branch Elementary School, where we intend to send our children. The house was designed in 1940, and it doesn't really work for, young kids. I've got a daughter who will be 2 next month, and she's still in a crib most nights in our room because the stairs to go upstairs are just too steep to be worrying about a kid up there. And so we also wanted to preserve the backyard for play space. And so our wonderful architect, Sarah, has created a very beautiful design that will work better for our growing family. We're hoping to make this our forever home. We're half a mile from my parents' house, a mile from Bill's dad's house. Like, we walk there all the time. And so we're really just hoping to make it a home that can work for us for, frankly, the rest of our lives.
Any questions of Ms. Turner, the applicant?
Mr. Chair, I'm
Mr.
prepared
Mellon?
to make a motion if there's.
Well, Ms. Riddle Moser, you didn't sign up to speak, correct? Okay. Hearing none, I'd be happy to entertain any motions if there's no discussion.
All right. So in case V11489119UP1, I move that the Arlington County Board of Zoning Appeals grant the use permit request with the conditions as stated in the staff report.
Mr. Chairman.
Is there a second?
A second.
It's been moved by Mr. Melnick, seconded by Mr. Owen to grant the use permit in the subject case. Any further discussion of the
Mr.
motion?
Chairman.
Mr. Owen.
I just note that technically speaking, it doesn't appear we got neighbor feedback from the school. And in this particular application, it's difficult to imagine how the school would be affected. But I just want to go on the record saying that ideally, the school would somehow be contacted for their comment as well.
I would have sent an email to the superintendent. I'm just, if I were in your shoes, I sometimes say that, but because actually the schools have been before us for the placement of, they call them something other than trailers, movable classrooms or something.
Yeah, something.
Have been before us.
It goes by any other name. It's
Yeah,
still a
it's still a trailer, and also for the their bus parking line along 395. No further discussion on the motion. All in favor signify by saying aye.
Aye.
Aye. All opposed, the ayes have it. The matter is granted. Thank you very much.
Thank you so much, everyone. Have a good night.
Mr. Rissy, please call the next case.
Case number V-11490-19-UP-1 is a use permit request by Mark Gray and Jennifer Gray, the owners, to submit a street setback of 19.9 feet to the wall, and eave of the addition from the 26 north right-of-way instead of 25 feet to the wall and 21 feet to the eave as required, and to permit an aggregate side yard of 17.5 feet instead of 18 feet as required regarding a new one-story front garage addition in the R6 zoning district on the premise known as 5274 26th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much, Mr. Rissy. Any questions of
I had a
Secretary?
question.
Ms. Malice?
I'm looking at the tax map and the shaded area. Am I the only one that sort of has that blue area bifurcate the building?
No.
Nope.
What does that mean?
That means that the applicant owns 2 parcels that the house sits on.
Yes, the house is relatively.
No, I'm still with Mr. Rissy.
Yeah, go ahead, Mr. Rissy. We'll ask for your further elaboration on this unique situation, too.
So only this parcel is under consideration?
No, the parcels are together addressed with the same address.
Okay, so it's just a coincidence, I mean, just the fact that both aren't shaded?
Yes.
Okay, there's no significance to
There's
that.
no significance to the
That's all I
highlighting.
wanted to know.
They're numbered both the same? Both those structures?
There's only one structure.
There's one structure, two lots.
It crosses the lot line.
It looks,
No, I'm looking at this tax.
I'm looking at the picture too. Yeah, I see that, but I'm looking at this photograph and it looks like it's through another structure. But okay. Mr. Gray, welcome.
Thank you very much. First of all, I'd like to thank Mr. Reese and his staff. They've been extremely helpful to prepare me for tonight and to do all of the background work and ask the really hard questions. So again, thank you very much. I appreciate everything you've done. It's a relatively small house, as you can see, spread over two lots that were at one time owned by, I guess, apparently two different developers. So it's actually a lot and a half. So that's why it's a relatively small structure on a large lot. It meets the criteria set out by I believe, the standards, the 4 points that they had made in the request. So in that way, it is also compatible with the neighborhood, and it would only increase the actual footprint of the house on the structure by a relatively small amount, I believe only going up to 18.9%. With that, I would recommend or request that you would accept the recommendation of the staff.
Thank you very much. Questions of the applicant? Hearing none, I'd be happy to take a motion.
Mr. Chairman?
I had questions.
I'll let Ms.
Ms.
Malice go
Malice?
first.
They may be the same, I don't know. I'm going to ask about curb cuts and,
I have those two, so why don't you start?
so right now you have a curb cut in your existing driveway. You'll have a new curb cut in your new driveway. What happens to the old curb cut?
We would probably want to comply with the environmental standards that are set out to get rid of the old driveway, and we'd only have the one driveway on the 2 lots.
Does the applicant responsible for making the changes to the curb?
Yes.
Okay, so is that shown in the drawings?
I believe they have shown in the drawings the old driveway as
I'm not sure if I saw it clearly.
the demolishing of the existing driveway and the existing walk. So they're showing it to be removed, which they would have to then update to the curb standards of the county.
That's part of the building permit?
It's part of, yes, the DES requirements.
They would require, if they demolish it, they'd be required to replace it, okay. And the other question I had was on the depth of the garage.
Yes, ma'am.
It's 25 feet, is that what I'm saying? Is that, 21? Oh, I'm sorry, maybe.
No, I believe you're correct.
I see, this one says 25.
No, you're correct, ma'am. It is 25.
25. It made me go measure my garage. It made me go measure my garage depth,
Okay.
and my garage is only like 20. Is
Yes.
this deeper than usual?
It's a few feet deeper, but like I said, for a pickup truck or for a large vehicle, that's about the size you would need. And I might actually put like a snowblower in there too. So.
A what?
But a snowblower or something
Okay.
else in there. But
Except
like
for
I said,
storage, yeah.
For storage. But yeah, for a large pickup truck, that is pretty acceptable when you add the garage door into.
Are you seeing a discrepancy? So what I'm looking at is sort of, it's been penciled in.
Right.
This is the width, 2111.
Mhm.
This is the length, 25.
Okay.
Or depth.
Thank you.
Any further questions, Mr. Owen?
I have some questions for staff, and I might turn back to the applicant after that.
Okay.
My first question is, following up on Ms. Malice's question, does this application require the applicant to get the curb cut in front of the old driveway removed?
So we've actually been emailing back and forth in the last couple days. That isn't a requirement of the zoning ordinance, but that is a requirement of the DES construction standards. They would they typically only allow one curb cut per property. There's discussion with the applicant that we won't get into here. But that they expect that the old driveway would be removed and returned to a standard curb condition for allowance of the new curb cut.
Standard curb condition, okay. Not so long ago, we had someone propose a carport in front of their house, and the staff compared the setback distance for the carport to porches that were in a nearby neighborhood. Here, an applicant is proposing an enclosed garage, and once again, it appears that the staff is not exclusively, but largely comparing the setback distance from a garage to porches. And I'm wondering, we had a lengthy discussion last time about the county policies about porches as opposed to things that are not porches and so forth. So just let's very briefly recap. Does the county, say again? Oh, does the county have a policy promoting front porches?
Arlington County does not have an explicitly written policy favoring promoting front porches. However, unenclosed porches on the front of structures are the only porches that are qualifying for the additional density bonus. So through these regulations in the zoning ordinance, the county board incentivizes those porches by allowing an additional 3% main building footprint and lot coverage for them while not incentivizing enclosed porches or other structures.
It seemed to me, and I might have gotten this wrong, but it looked like the comparisons that were not porches were to building walls, and that both of them may have been on corner lots. Is that correct?
Correct.
So, do you know, what is the closest parcel to this site that you know of that you could readily find, knowing that you can't find everything that exists because the records aren't complete? What would you say is the closest parcel to this size on which an interior lot has a front setback smaller than the applicant has requested that is not a porch?
So I can't say what the closest parcel to this on an interior lot having a smaller setback to a building wall than the applicant has asked at this time. I'll just say that we included the corner properties because the setbacks are the same. They're 25 feet regardless of whether it's corner or interior.
Okay. I think that's it for my questions for staff. For the applicant?
Please, go ahead, Mr.
Can you go into greater depth about, in your application, you said that there's problems with the availability of parking in the street in front of your house. Can you go into a little more detail about the nature of the problem that exists in front of your house?
Yes, thank you. Excellent question. Well, if you would, in the other direction is Yorktown High School. And every Friday night they have large football games there. So parking is always at a premium on some nights. In addition, we now have some staff that do work for us occasionally, whether nanny for our children parking, cleaning services coming in, men with trucks who come in and do the grass mowing, both for myself, for our house, and for the houses in our neighborhood. And finally, we also recently hired a tutor for one of my daughters who's parking on the street. Sometimes in the evening, there is a premium of parking in that area. I know that there is the possibility of getting a zoning permit to only allow...
Zoned parking.
Zoned parking, thank you, sir, for that, but we have not investigated that at this, sir.
Seems like staff has something to add to that.
Go ahead,
Staff
Mr.
was asked
Ricci.
this question as well, and staff actually went to the county's residential parking permit program's website, and this address is not eligible for the parking permit program at this time.
Well, none is because there's a
Because
moratorium.
there's a moratorium right now.
My question was, if there weren't a moratorium or once the moratorium is listed, has it been investigated for zoned parking?
My understanding is this is not an eligible location, but it is a limited investigation that staff was able to do.
Yeah, I don't know why it would be, but
Maybe because of the school.
I don't think that's part of the RPP conditions. There's not a limitation on near-to-school parking at this time that I know of. All right. I think that's basically it for my questions for the applicant and staff. I have other discussion that I would want to have, but not in the form of questions.
Any further questions of either staff or the applicant? Okay, hearing none, there are no other speakers signed up, so this matter is with the board.
Mr. Chairman.
Mr. Owen.
I think this overhead photo actually very clearly, that's up on the screen right now, very clearly indicates or illustrates my concern with this application. You can see all on the row from the left to the right, you have 7 properties in a row that basically have their fronts situated along a line. And you have little tiny incursions for little porches and stuff, but you don't have any major structures protruding. Then you have that gigantic house all the way on the right-hand side. And it has a garage that may be similar in size to what the applicant is proposing, at least in terms of its width. I don't know what its depth is, but yeah, it's set back much farther from the street. And so its visual impact is mitigated by how far set back it is. All of the lots on this row have extremely deep lots. There's lots of space in back, but they're kind of close to the front. And so I guess I'm just sort of troubled by the size and placement of a garage of this size in this location as being compatible with the surrounding properties on this row. I think that it would encroach quite a bit more than what we find on the surrounding properties. And there's an existing building, and so it's obviously much more expensive and difficult and, challenging to knock down and move back. I think the applicant is proposing other improvements on the property. I think I remember there's a by right rear addition that's already part of this proposal. But it's not clear to me why, in this kind of situation, we wouldn't have an expectation that the driveway would, that the garage would, in fact, be in line with the building line or much, much closer to the by right building line and make better use of the property in the back. In fact, it looks like the main house isn't part of the line of sight for this driveway, that we're talking about what already was probably an addition that could be scooted back. And I can see an applicant's interest in saying, well, I'd rather not mess with those walls and those footings, and I'd rather just stick the driveway, the garage in front. That's a cheaper, more efficient solution. But I just don't. I'm disinclined to think that this meets the criteria of being compatible in size and placement, similar in size and placement to the surrounding lots.
Okay. Yeah, it looks like the depth is 21 feet roughly.
25.
Well, to the front of the garage, 20 feet, 11 inches.
And I guess I'll also add that farther down the street, there are some garages that are pretty close. I mean, a lot of them don't have garages at all. But
Right.
of those that do and have garages that are closer to the street, they're one-car garages. They're much narrower and less imposing. And the only garage that I saw that seemed to me to be similarly imposing to the proposed garage here is that one 2 doors down for the house that's much farther back.
Yeah, and but there really isn't a way to put the garage in the rear, basically, because we don't have, the drawings don't show what, I imagine you can enter the home from the garage, but we don't have any of the interior, so you're actually going to make significant changes to that corner of the house at least, and probably significant changes in the interior on that side.
Yes, sir, may I speak?
Yeah.
Sir, thank you very much. Yes, you're correct. And if Mr. Owen's suggestion is that we demolish part of that house or half of that house and move the entire right section back, I believe it would be more likely that we would just demolish the entire house and then put up a very large structure like you see.
Yeah.
So if that's the goal, to occupy more of the square footage and replace it with a large house, that would probably be the option. We, as you said, would be much more interested in preserving the 1943 house and pretty much in its condition as it is right now. Not only because it would, we feel, it would be, like the staff recommended, it would be consistent with the character of the neighborhood, but also it would be a very valuable addition to that neighborhood. So yes, there is a possibility that we could do other things, but it would just be very costly prohibitive to do that. But I do take Mr. Owen's points.
Yeah, and to be clear, I don't think, I mean, we don't have all the information, right? So perhaps you're right, the whole, much would need to be demolished, but I'm not convinced that much would need to be demolished. We're talking about, what, 7 or 8 feet to move it back within the lot line, the by right lot line. So, much of it could be preserved or altered, but I have no reason to doubt your analysis. You probably went through that analysis already. But you're not proposing to put the whole garage is being proposed to be put to the right of the chimney, right?
Yes, sir.
So everything to the left of the chimney could potentially stay just as it is. It's only the stuff to the right of the chimney that might need to be moved back 6 or 8 more feet.
Well, that looks like an addition that was done a long time ago.
Yes, sir. It's more than, now it was built in the early 70s, so I was going to say 30 years, but now it's almost 50 years old, that addition. So it was 1973 for the addition. The house, I think, was 1943 by my recollection. So like I said, we chop that addition in half to take that 7 feet out, as Mr. Owen just suggested, to move the garage back. That would be fairly prohibitive as well. So I think the staff analysis is very good, and again, I would request that you consider it.
So, Mr. Chairman?
Ms. Malice.
Just to that point, the staff analysis that we're concerned about is comparing a garage to a front porch. We would not want that to stand as a comparison for other sites.
Yeah, and that's more of an internal kind of an issue that, with respect to our review of the staff's reports and how they come to the recommendations. It looks like the setback to the house is about, I would say in the neighborhood of 35 feet, roughly. So you're going to eat into, I can't tell what that niche is, 4 feet. So, I mean, almost a 20-foot setback for, I mean, the point that Mr. Owen is making is that when you see that, you see a series of houses with garages in the front that are roughly the same distance from the front yard setback, but that, in this block there's, well, we only have this photo which shows 1, 2, 3, 4, 5, 6, 7 structures. That one that's next to the big one with the circular drive, that looks like it's closer. I don't know how far forward it comes. The one directly across the street, the house directly across the street, doesn't look like it's set back as far as your house is even. It's hard to tell, though. And the house next door to that, the one on the corner, kind of kitty corner from you, looks even closer.
That's correct. They have very small lots. I think the corner lot also has additional, they're both corner lots. I believe they have additional restrictions on them.
Well, I don't like comparing garages to porches. I think Ms. Malice is making the point visually they're altogether different. And then the earlier point, the question of Mr. Owen with respect to staff about what is the policy of the county with respect to porches. Obviously, porches are favored. Garages are not disfavored, but they're not given that favored status that kind of porches are. So I don't have a problem with the garage. I think the character of this neighborhood is kind of a eclectic, to put it nicely. You have this new big house on one end and a lot of, as you say, 50 or more year-old structures that have had that have been remodeled in various ways.
Mr. Chair, Mr. Chairman,
Ms.
could I
Mallett?
ask a question for staff? I'm just looking at the plat. Back to the tax map, the section of the map where the garage would go, that half lot actually juts out into the street.
Yes, a portion of the garage would be further from the street than the 19.9 feet that the applicant is requesting. There is an issue where the two lots have two different placements on the street.
And so where did you measure from?
The closest.
The closest?
Yeah.
And so is that little, I can't tell, is that little piece in an easement area? Or is that county right, not county? That it just happens that the street is built on his property. Is that what we're seeing?
So, looking at the plat, lot 33, or the part of the lot that's labeled 33, has the street property line delineation at the rear of the 4.5-foot sidewalk. The partial lot 29 has the delineation
Got it. I see it now.
on the opposite side of the sidewalk.
So yes, so the concrete walk is on his property.
On the portion of lot 29, correct?
Right. Right. But the measurement that's 19.9 is from then the front of the sidewalk?
It's the back of the sidewalk closest to his house where it steps in and would be closest to the proposed garage.
So it's 19.9 to the back of the sidewalk,
Yes.
the portion closest to his house? Okay.
And the sidewalk is 4.5 feet. So really, on the other, on that part 29, it is 24.5 feet.
Back from the property line.
Yes, 4.
Roughly 24 point.
Yeah, 4.
4.
Yes.
Almost. That's why we're here. That's very interesting. Thanks for pointing that out, Ms. Malice. That kind of helps the applicant, actually.
Yeah, well, I'm trying to look at it from all sides.
Yeah.
Thank you,
Yep. Kind of odd. Well, that makes it, as much as I don't think garage is the most attractive thing to see on a streetscape, I don't think it's a lot. I don't think it's a stretch. I don't necessarily, again, don't like the comparison to porches or the like, but you compare it to what's there. So, any further questions or discussion? I'd be happy to entertain a motion of any kind, as would the majority in the audience, I'm sure. Ms. Freshman.
Drawing the short straw. I move the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11490-19-UP1 subject to the conditions listed.
Is there a second? Been moved by Ms. Freshman, seconded by Mr. Melnick to adopt the attached resolution granting the use permit in the subject case. Any discussion of the motion? Hearing none. All in favor of the motion signify by saying aye.
Aye.
All opposed?
No.
By a vote of 4-1, your
Thank you very much.
application has been granted. Thank you.
Thank you very much.
And please call the next case.
Case number V-11491-19-UP-1 is a use permit request by Niles and Kelly Polson. The owners submit a street setback of 16.6 feet to the wall, 15.6 feet to the eave, 13.1 feet to an attached planter box, and 16.6 feet to the deck from the North Garfield Street right-of-way instead of 25 feet to the wall, 21 feet to the eave, the attached planter box and deck as required, to permit a street setback of 10.7 feet to the new sunroom eave from the North Garfield Street right-of-way instead of 21 feet to the eave as required, to permit a left side setback of 7.8 feet to the wall, 7.9 feet to the screen porch instead of 8 feet to the wall and porch as required from the adjacent property line, and to permit a structure of more than 2.5 stories within 25 feet of the right-of-way. Regarding a new rear addition, deck, and screen porch on a corner lot in the R6 zoning district on the premise known as 2928 2nd Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions of Mr. Rissy? Hearing none. Niels Polson?
Nels Polson, thank you. It's pronounced Nels.
Nels
Thank
Polson. Welcome.
Thank you.
Anything to add? Any comments you want to make?
I'd just like to thank Mr. Risi and his staff for all the work they've done. I know Mr. Risi was working late last week, so appreciate that. And the board for your consideration. I'd just like to say my wife and I have been longtime Arlington residents. We've been living at 2928 for the last 3 years. We plan to make this our forever home and hope to walk our son Lucas to Long Branch Elementary, which is just 2 doors down, with a new addition that hopefully adds to the character and value to the neighborhood.
Any questions, Mr. Polson? Hearing none, matters with the board. Be happy to
Mr.
entertain
Chair,
a motion.
Mr.
Ms.
Chair.
Freshman? Oh, Ms. Malice.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11491-19-UP-1, subject to the conditions listed.
Is there a second?
Second.
Thank you. It's been moved by Ms. Malice, seconded by Ms. Freshman to approve the attached, the resolution in the instant case. Any further discussion of the motion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Aye. All opposed? The ayes have it. The matter is granted. Thank you very much.
Thank you, board.
Please call the next case, Mr. Rissy.
Case number V-11492-19-UP-1 is a use permit request by Jason and Susan Ham, the owners, to permit a rear setback of 1 foot to the wall and eave of a detached accessory building shed instead of 10 feet as required from the rear property line, and to permit a separation of 5.5 feet between a main building and accessory building, 1.5 feet from the eave instead of 8 feet between the building, 4 feet between the building and eave as required. Regarding a proposed bike shed on a corner lot in the R5 zoning district on the premise known as 1038 17th Street South. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions. I'd also like you to please note there is supplemental material for this case that came in after the application packet was assembled and printed. There's a letter from the adjacent neighbor.
Thank you very much. Let me see here. I do have that. Give me just a few seconds here to peruse this.
Mr. Chairman,
Mr. Owen?
I have a question for staff.
Go ahead, please.
We received an email, as you mentioned, from Nima Bina. Do you know the property address for Nima Bina?
Yes, she is the adjacent neighbor sharing the left property line, the neighbor at 1034 17th Street South.
Thank you.
Say it again.
1034.
I believe her address is listed at the end of the email, possibly on the back of the first page.
Okay, I've had a chance to review it, and
Oh, there it is.
any other questions of staff? Go ahead, Ms. Freshman.
Just what's the coverage? The coverage is 39.9 now, and what's the max for the zoning? I mean, usually it's in here, but, and I do not commit it to memory. I guess the basis of my question is, this is a ginormous house on a
Large house.
and they're putting something more on it, so I wonder about the coverage.
Yes. In this case, the coverage is not impacted as the accessory structure, which is detached from the structure, is less than 150 square feet.
Okay.
But the coverage is that correct? 39.9%?
Yeah.
That's the current coverage.
Okay. Any other questions of staff? Susan Ham, I presume.
I am Suzanne Fife. I'm the landscape architect.
Oh, okay.
The owners were not able to make it, so I'm standing in for them.
I've got a speaker slip for you. Then the applicant's not here, or is not going to make a presentation?
I'm sorry, I didn't understand.
Jason and Susan Ham.
They are not here.
Okay, fine. And you're representing them. Welcome.
Thank you.
Anything to add?
Just,
Have you had the opportunity to see the email from the neighbor at 1034?
No.
Niambina? Yes, absolutely. It was received today at 5:19 by the zoning office, so you may not have had an opportunity to see
Okay.
that.
Thank you.
This is a neighbor who is complaining about the propensity for water to impact her, which she's already experiencing.
Is she to the left?
Yes.
If you're looking at the house, it's to the left. Does she own that house?
Yeah, I know. We don't know, but they're the resident.
So she's concerned with the eaves?
Well,
That's not,
that's one of the issues, but in general, it seems like she's concerned about water. The size of the big house on the small lot has caused the rainwater that prior to rebuilding was absorbed by its own land is now causing an excessive amount of water standing in my yard after each heavy rain.
Mr. Smith,
Mr. Rissy?
if I may, the author of the letter is here and may elect to speak.
Yes,
if
no,
you
we
call
have,
for it.
yep, I got a speaker slip from her. But I just wanted the applicant's representative to be able to respond, because I'm sure that's going to happen. So, if you don't have anything to add right now, we can call you back up after the neighbor has spoken.
okay, yeah, I don't, does this seem to affect your thoughts on anything?
Well, their view is
We
that
we have an obligation to only approve use permits that do not cause detriment to other property. And we have an obligation to evaluate, for example, whether or not it's compatible with the natural landform. So it appears on its face that it
Take a
addresses
tree.
some of those issues.
Okay, I do not think that we're going to cause any more water problems on her property because, and actually, instead of it says that it's the whole side of the property is going to be like a wall because the house is there, and then, but actually there's a fence there now, and we're actually giving her an extra foot because we're not going to put the fence up behind the shed. So we're giving her an extra foot of space because it'll still be their property, but we're moving it a foot in. So right now, the fence is on the property line and falling down, which we will have a straight wall now. As far as the shed and it being part of the house, it's a very small shed, not higher than the 7'6" that's allowed, and we're going to paint it to look like the house so it kind of goes together. It's just going to have bikes in it because their family is avid bikers. They've got 4, and there's no place in the house to put them. So they just wanted a little shed to put them in. And we designed it in an L shape so that it would not take up the whole space in the back area. So, did you have any other questions?
Well, I presume that the eaves were built by right.
Those are part of the house. I don't really,
Right.
I came in after the house was built. We're just putting the shed in.
So
I
we don't really have anything to do. We're only talking about the creation of an accessory structure, and you might want to speak to how water from it will be.
We have a rainwater detention area in the front, and all the pipes are to go in that rainwater location.
Does the shed have gutters?
Pardon me?
Does the shed have gutters?
No, it does not.
Does the shed have a pitch that faces the fence line? Is it a double pitched roof or a single pitched
It
roof?
is pitched.
Yeah.
Like an A shape.
Yeah. Actually, the shorter side's in the front. We can shift it to the back, but very little water is going to go off that shed to the property. And actually, it should be falling onto our property because there is no eave on the back of the shed because I didn't want to encroach the 12-inch line. So it falls directly off of the shed and onto that 12 inches.
Okay, thanks.
Speaker?
The L shape, this is an L shape. One of the sides is along her fence line, isn't it?
They're both along the fence line that's in the corner.
Yeah, but I mean, one is along the fence line that's the fence between this structure and 1034. So I think the point is that water runoff from it, that pitch on one side will flow toward 1034. There's no gutter. It's not being retained on the roof, so it does flow off. How is that being
Flowing
handled?
off into our property, though, not onto her property.
Okay.
Because we have a foot of water that's going to go right onto that.
But if there weren't a structure there, it would be absorbed into the soil. It'd be an impermeable surface. The point we're making is that the roof is a non-permeable surface, so it flows off of that.
Right.
And where it goes is the concern of the neighbor who's most directly affected by this, at least on one side. The rear is the other. And the one directly affected on the facing to the left is concerned about water. It has an issue already with water without this additional non-permeable surface being added. So the answer was there are no gutters to direct that rainwater into a specific area.
I could put a gutter on it.
But that would then encroach into the side yard a little bit further.
Staff does
The amount
not.
of water
No?
would be
Okay.
a gutter this big. to hold that amount of water, so. And we could wrap that around and put it back on our property.
So you would accept that as a condition
Yeah.
to direct the flow? Okay. Well, we're going to, question?
Just want to, tell me again why it has to be in this location?
Why? There's no other space.
There's no other space in the backyard to put this?
Oh, yeah.
No backyard.
We tried every location possible.
It's a huge house.
But, well, I mean, what am I looking at here? There is space behind the house, right?
But look.
No. If I may clarify, the plat that you're seeing is a wall plat that was done at the time the foundational walls were completed. If you advance the slide again, you'll see that there is a screen porch that is not located on the wall plat survey. Nope. Keep. Go the other way. No. There. No. Yeah. Back one. There's a screen porch right there.
Oh.
So on the west side, there's a screen porch.
Yeah, so see this plat? There's a porch.
Right,
in
right,
here.
right.
This whole area is built.
Yes.
It's terrible.
Oh, because this is from 2013, the plat that we're looking at. Okay. So certainly along the side yard, which is next to 1034, a gutter would be helpful to handle the water and direct it into a,
Put it in a rain barrel.
yeah, in a rain barrel perhaps.
I could put it in, might be able to get it to the rain garden. It's kind of a long way.
Well, it could be directed off the other side. If the rain garden is to the right, you could, you know, how the gutter can capture, close it off on this end. But in any event,
Mr. Chairman.
Mr. Owen.
Two things. One, I'd love to hear from the other witness if there is one, but I also, while this witness is here, I just wanted to say if she could explain how the fence compares in height or elevation. How does the fence compare in elevation to the top of the pitch of the proposed shed?
Same as it is now.
So the fence height with that sort of trellis top there is the same height as the proposed shed height?
7 feet 6.
Thank you.
Okay. Any more questions of the applicant? If not,
If we do put a gutter on, I mean, I have to find a miniature gutter, or maybe you just handcraft it, but can it encroach the 1 foot line? Or do I need to move the shed back so that the outside of the gutter is 1 foot?
Zoning doesn't count gutters towards the encroachment. We measure to the eave of the structure, not any gutters attached thereto.
there you go. So you measure to the eave, not the gutter.
Can I ask you a question?
Okay.
Ms. Freshman?
I'm looking at the neighborhood outreach, which seems to be minimal. It's apparently a letter circulated by you, or at least written by you. I don't know whether the owners went to their neighbors. There seems to be only a handful of people, some of whom don't live that close to the house, that have submitted any comments.
Have agreed that it's okay?
Mm-hmm.
Yeah, because, I mean, we typically want all of the surrounding neighbors across the street, behind and all on. Now, we have the one behind and we have the one beside who is objecting. But all along Garfield and other streets, there's not input. I believe there's one here that doesn't have an address, so that would be helpful.
And there's a couple of people that don't even live in the houses around there. I have tried knocking on doors and they're empty. So,
So this notation that lists a whole bunch of addresses with
Not home?
comments like not home and stuff.
That's not acceptable.
I was walking around trying to knock on doors of people that were mostly on corner lots but also the neighbors that had garages in their backyard or side yard.
Okay.
Ones that, I don't know, Mark had said get as many neighbors as you can that say they don't care, or it would be fine. And most of the people we met walking dogs and on the street said, it'll be fine. They didn't really have a concern with it. I think the lady on the neighbor on the side, I think she's renting. I don't even think she owns it. And she, I don't know, I think she's always been very, none of the neighbors have been very enthusiastic about her being there. And it seems to
Well,
be,
I don't think this
she has
is,
a
this
tendency.
isn't the right venue for acrimony. I'm just making a point that we like to have neighborhood input. And if this page is correct, it says visited on Saturday, August 14th, so that means a one-time effort to go out and try to get some support. That's really very minimal.
And it indicates that that neighbor wasn't home, but you're expressing something a little different with respect to, you're kind of describing the personality. But we're going to hear from that person. Any more questions
No,
of,
thank you.
of the applicant's representative? Stand by, though. Ms. Liajhat? Liajhat, 1034 South 17th Street. Welcome.
Good to see you.
Must feel odd being talked about and hearing it.
And not being seen, yes.
I apologize.
That's
Welcome.
okay.
Please give your name and address for the record.
My name is Miss Liagat, 1034 South 17th Street. I
And you
am the only, sure, can I start? I'm the only property owner who is totally affected by this huge house. So all other neighbors, if they come for or against, nobody has been affected. And for the past couple of years that this house has been built from a 1,000 square foot to about 4,000 square foot, I have increasingly and adversely been affected. Whenever it rains, I go with the backyard in standing water. In the winter, the snow doesn't get melted. When you look on the pictures that I sent today in comparison, in this page, if you have it, comparison of the house, it shows from when I look to this house from my backyard, I see the whole length of my house is almost this house. This house is like a wall. And if this shed is built, which is 15 foot long, along the side of the corner of my lot, is going to be I'm totally covered, the whole length is covered by a structure. And that, the extra adverse effect that it has on me is that the height of the house, this house, is blocking the sun. So for half of the day, almost half of the day, I don't have any sun. My side yard doesn't get no sun at all. So it prevents the snow to get dried or the rain to get dried. And also this only this 10-foot left that allows a little bit of air to circulate. As you know, for the yard to get dry, you need sun and you need air. This whole house has been blocking the air and the sun. And this little space that brings a little bit of air to circulate, if it is built, then that is also preventing, and so it's going to make the problem worse. This is where I see it.
Let me ask you.
And also,
Is your house downhill from this house?
No, it's almost the
Is it
same.
level?
It's the same. Yes,
Okay.
it's the same level. And also, Several months ago, I brought a contractor to tell me what to do about all this water in my yard. They said, well, of course, the issue that I explained to you, that's what they brought to my attention. But then they said, I have to make dig a big, like a pond or something in the backyard, in my backyard, change the slope of my yard, so all the water to go to this pond. Then from under that, have one or two pipes taking all this water to the front yard toward the street. That's going to cost me somewhere around $10,000 to do that, to just get, and that is still not going to solve the issue, but to remedy a little bit. And as I said, I'm at the receiving end of these permits that the county keeps giving. And I know you, in the beginning, you said you're not responsible for that. I do understand. When I mentioned these eaves that has been pointed to, I know it's not the subject that is going to be discussed today, but I want to tell you that this house mostly has been built based on exceptions, and tonight is being asked for another exception. These eaves, when I talk to the contractor, these eaves are not doing anything for their house. It's ornamental, but the effect of it is that there is supposed to be, the building is supposed to be 8 foot from my border, but these eaves has made it to decrease it to 5 foot. So the rainwater is coming down. And then when since the whole house has been built, before they built it, all this rainwater was being absorbed by the grass and the land, and now nothing. And as you see, even in this section that they're talking about putting a gutter, they already have put slabs of concrete. So where is that going to go? It still is going to, eventually, since it's not going to be absorbed by their land, it's going to somehow come to my land. And as you know, that area, the water table is high, in addition to the clay soil. So I'm getting more water in the cinder blocks in my foundation, and I'm really concerned about the future of my building. So I hope some of this goes to the county and tell them to change the cause, or not to give so many, not to give so many just exceptions.
Excuse me, can I just interrupt you?
Sorry.
No, don't
She has
don't
a
go
question.
away.
Go ahead, Ms.
But I'm
Malice.
going to direct it at staff. You are saying that there was some special permission given on the side setback?
None from the Board of Zoning Appeals that staff was able to find.
I see nothing here.
But there is exceptions to the
8-foot
8-foot
rule for
regulation that are in the zoning ordinance. Eaves are allowed a 4-foot encroachment so long as they are not closer than 5 feet. It's an allowable encroachment under the zoning ordinance.
So the wall is 8 feet, but the eaves can encroach to within 4 feet? 5 feet of the side yard setback, so.
Within 5, so a 3-foot eve,
Yeah.
leaving a 5-foot. Okay.
Which is, as this neighbor says, it's ornamental in one respect, but it also kind of shades the side of the house
Right.
from direct rainwater. Kind of, the bigger the eave, it preserves longevity of the wall. The less water hitting, the better it is. So the big eaves minimize the water that's hitting. But of course, it means, now you did take a good picture though of this drain spout on their house, which is directing the water into a storm drain, which means that another gutter can be placed on the shed to also direct this water either into the storm drain or into some catchment. So that's what we were discussing with the applicant, is the ability for them to put a water diversion mechanism on the structure should they be given permission to put a shed there.
May I also add something? Maybe.
We don't, unfortunately, our clock doesn't appear to be working.
Okay.
I have surmised that you've gone beyond the time, but if you would wrap it up, I would permit you to do that. our clock is not working. Usually there's a timer and it has lights, as you see in front of you, and it gives you kind of a countdown. But you can finish your point, and then we'll return to a discussion of the matter. Anything else you want to add?
Yeah, may I? Yes, please. Thank you for giving me additional time. The slope of the roof right now is steeper than
steep.
the original one. So I asked the county. First of all, two of their gutters in the front section of the building is not tied into this rainwater system that they have. And I've asked the neighbors several times to please connect it together and get it out to the front yard, because their distance to me is about 3 feet in that section. And it is right at the border. And they refuse to do that. So there is no consideration on that, unfortunately. And the slope, when the slope is very steep, and the gutter is only 4 inch, is not going to catch all the rain. Some of it eventually is going to come to my yard, and that's what's happening. So that's another code. Then the county doesn't have any code regarding the gutters and the spout arms.
Okay, thank you very much. We've heard you.
Ma'am, I just...
Mr. Owen,
I'm
stand
sorry.
stand by, Ms. Lehat.
I'm sorry to drag this on, but what is the thing that you just said they refused to change?
There is the section in the front part, the front section of this whole house, which had the 3 foot from my yard. They have, and they built it on that ground. They ruined it and then they built it. That gutter comes down. It drips right there. It's not connected to any of their system. And so I asked them to these two that is closest to my yard, connect it, get it out. They didn't.
Thank you. Thank you. That was very...
Okay. No other speakers. Anyone have any additional questions of the applicant's representative? I want to ask, if you may, Ms. Yaffe?
Suzanne Fife.
Fife. F-Y-F-F-E. Okay. You heard the neighbor, and I saw you nodding at one point when I was pointing out the storm drain and the downspout. So it's possible to put on an accessory structure gutters.
It is possible to put a gutter on the accessory structure and connect it into the storm drain and have it go out. And I also would say that I will have my contractor double check all the storm drains to make sure that they are leading into the rain garden where they're supposed to be. And I'm not sure I understand the front situation, but we can.
Well, that's not material to your application.
Thank you.
Well, it is to goodwill.
It is to goodwill. It's absolutely right. But I think it was done by right, and it's but with respect to even the goodwill efforts to mitigate whatever any additional roof might cause in terms of water runoff is the kind of thing you want to do, because the neighbor is saying that she's adversely affected, and without gutters, there's no disputing the addition of a non-permeable surface is going to, the water has to go somewhere. She's saying there's a low area already. Water does what? Seeks a low spot. So, what's the answer? How would this project be? How could it be changed to minimize that kind of adverse effect?
Can you repeat that question?
What can you do to minimize the effect of stormwater runoff from this additional structure?
We will put a a gutter along the outside, and we won't make it small, we'll put it large enough to collect more than enough water that will then go into a rain barrel or directly into the stormwater rain garden drain. I just don't know where that is, but yeah, we will keep the water on our own property and into the rainwater
Mr. Chairman?
garden.
Ms. Malice?
I'm just to sort of move the discussion along, I'm concerned about this application. You know, if there's a water problem, putting a shed that runs, what is it, 15 feet along the fence? I think you could reasonably infer that that would contribute to more water problems. So I don't think I would support this as it's presented.
Mr. Chairman?
Mr. Owen?
In case, where are we? V-11492-19-UP-1, I move that the Board of Zoning Appeals deny the application.
It's been moved and seconded that we, moved by Mr. Owen, seconded by Ms. Freshman, that we adopt a resolution denying the subject use permit. Any further discussion of the motion?
Excuse me, did you just deny it?
That's what is proposed. That's the motion.
Is it to,
Mr. Owen?
We have a motion.
Ask that we follow our rules of order in terms of how we organize our discussion.
Absolutely. But I do want to address, if there's a question, if there's anything that could, I mean, if you can say anything, I'll give you 30 seconds. What we just discussed was the merits of the proposal. It seems as if there's a majority that doesn't favor it. I don't know that there is anything that could be said to change anyone's mind at this point.
can I understand what it is that is causing the denial?
Well, one of the elements is that
It's not injurious to property.
doesn't adversely affect the neighbors. We've had testimony from a neighbor
Right.
adversely affected. And now we have a motion that's been moved and seconded to deny the application. I mean, your client has the opportunity to appeal this, should the motion pass. They have the opportunity to redesign, come back with a different plan, should they like to put something back there.
I'm not understanding.
We don't
what the-
ordinarily debate our motions with the applicant.
We don't debate our motions.
No, I'm just explaining what's happening. And so that's kind of where we are.
I
Mr.
don't
Chairman?
understand why, though.
Mr. Owen?
Mr. Chairman, I would ask unanimous consent to revise the motion to include two findings.
Go ahead.
I would ask unanimous consent to revise the motion to say, whereas the BZA finds that the proposal would adversely affect the health or safety of persons residing in the neighborhood, and whereas the BZA finds that the proposal would be detrimental to the public welfare or injurious to property or improvements in the neighborhood, therefore, the Board of Zoning therefore be it resolved that the BZA hereby denies the special use permit case number V-11492-19-UP-1.
Mr. Chair?
Mr. Melnick?
So, Mr. Owen, if I could ask, when, you've heard about the possibility of gutters and the water going into a rain garden or a water barrel, what is the reason you think there's still issues, like if there are gutters and the water is guided? I'm interested to hear.
Well, that's not what's before us.
Not
What's
before
before us is a proposal that does not include those elements. Now, if somebody wants to offer an alternative motion for a deferral for specific purposes, I would be willing to entertain it, but the motion that I'm proposing to make is now a more complete motion for denial.
If I could, Mr. Chair.
Please, go ahead.
So you don't think there's enough information to have a motion approving it with conditions, in other words.
Correct. I don't think we can craft conditions tonight that would make it approvable in my mind.
Okay.
It may be possible with a delay and enough indication from all parties concerned that they would discuss, but so far I haven't seen that either.
Okay. Do you understand about the deferral?
I'm having a hard time with this because it was, everyone was saying that it was going to be okay, and then I get a piece of paper like 2 seconds before I get up here. I had no idea that there was a water issue in anybody's property.
Well, let me correct you. You said that, you provided evidence that nobody was home at 10:34.
No,
and
I left the sheet
and
there.
the neighbor next door apparently wasn't contacted at any other time. I think
Twice I went by. And
the neighbor showed up. The neighbor has understood that she has a right to speak up and has described what's adverse to her. And maybe your client didn't. What I heard was that you said that folk in the neighborhood had problems with this neighbor. Maybe there is some animosity which prevented them from communicating. And but I think what the neighbor expressed quite clearly was there are issues. Now, I do have to, if there's no further discussion of the motion, I have to bring it to a vote.
Mr. Chairman, first is my unanimous consent request to modify that.
And
Yeah, no objection.
I don't have any objections. So without any objection, the motion is modified to really add the rationale, which your client can then see. And again, I said they have two options. They can appeal, or they can come back again, file another application with a new idea.
That's if the motion passes.
That's if the motion passes.
A BZA member could right now move for deferral instead of denial. That's a procedural possibility.
Mr. Chair, could we ask the applicant if she would agree to a deferral?
Well, this is the applicant's representative. I don't know if she could speak to that, but
I would like to propose that we put large gutters on that collect all the water off the shed and put it into our rainwater system, and that we double check all the gutters on the house, which isn't really part of the shed.
Can't do that tonight.
But
if you want to come back with a redesign, and there is a member of this board that's willing to make a motion to defer for a couple of months, and there's a second,
Can I just say something that?
then you might have that opportunity. But otherwise, we have a motion on the floor with a second, and we're just discussing it.
I can understand why you're frustrated, but one of the things that we have to do anytime we adopt anything is conditioned on submitted drawings, for example. And we don't have a submitted drawing that addresses some of these issues, like gutters and all that kind of stuff. So at the very least, if you had probably till November at this point to work it out so that there's better feedback from the neighborhood and submit new drawings that at least address some of these drainage issues and any other issues that maybe your neighborhood outreach comes up with, that's an option. Right now, the motion is to deny it. Then it goes away and you have to start over. If there is a substitute motion that defers, it gives you time to regroup, rethink, redraw, because whatever is ultimately accepted has to conform. You're locked into whatever plans. We wouldn't want you to be locked into these plans if they don't include, at a minimum, gutters and other things that we've discussed. So at the very least, you need time to redo that. We don't redesign on the fly just based on discussions.
so
That's just an explanation.
it's just that you can't do an amendment that says we'll put a gutter on and in the proposal.
No, you don't redraw it, just keep it.
That's fine, I understand that. I gave plenty of notice for this, and there was plenty of opportunities for people to contact me if they had any problems, and
Well, really, no, it's not the neighbor's obligation to contact.
I sent a letter to everybody, and she got two
It's the home.
letters.
It's the person seeking the use permit to do that outreach, not reverse. It's not
Mr.
if you
Chairman.
don't like it, comment. It's you going out and making that connection.
Although I will say, Mr. Chairman, that most people don't have a lot of experience before our board.
True.
Right? And so I don't think that the applicant and their agent's conduct is outrageous. I think
No.
it was well within the bounds of normal.
Fairly
I
typical,
don't think the
actually.
neighbors' behavior was.
I never knew anything about a
I-
drainage issue. That has never come up in anything.
As my colleague said, I think it's understandable, the frustration, but I don't want either speaking for myself, I wouldn't want either the applicant, their agent, or the neighbor to feel that anybody, in my opinion, had prepared for this or engaged with the Board of Zoning Appeals in a way that was grossly abnormal.
Right.
Sometimes there's conflict in our proceedings. We're a quasi-judicial entity. We're here to resolve disputes. That's our job. And sometimes disputes are messy, and I think that's what we have on this occasion.
And just with respect, we've had a lot of discussion about how to improve neighbor outreach, and we've asked the staff when folk come in with ideas to express to them the need to make that kind of outreach. And many, many, many applicants come in and have done extensive outreach. Some tonight had really detailed outreach. But it's, in this case, where the indication is that a lot of folk weren't home, those folk who had good outreach, they went back. They went back repeatedly. And, it was really on the homeowner, not so much their landscape architect, to do that kind of outreach. It really was on the homeowner. And maybe they believed that wasn't their obligation, but that really is the way it works. And neighbors talking to their neighbors and showing them the plans and discussing is kind of what we expect, and B, what's kind of required, so that you do know what the feeling is of those, especially those contiguous, those directly affected. So, again, we have a motion before us. If there is another motion to defer, it's possible that we can defer, but I haven't heard that yet, Mr.
So, if you're willing to defer 2 months, then I'm willing to make the motion. Should I make the motion? Would you really like that to be considered?
As long as that gives me a chance to come back and put the gutters on, which I didn't have, or make it better.
Yeah. So
I
I'm prepared to
just had
make a
one
motion.
question. If we had gutters on this and it was collecting the water and I had said that in there, would there have been any problems?
That's hypothetical, but really, where we have evidence from the homeowner's representative that 1034 17's not home, and that's the only effort, then, the person immediately contiguous to that, really, you have to go above and beyond.
And I believe there was someone home and they didn't answer the door. So I didn't want to say anything, but there was.
Okay, well,
hard to hear the
I'll
door.
make a motion.
Go ahead.
Mr. Melnick?
Okay, so in case Z114921 UP1, I move that the Board of Zoning Appeals defer this case until the November BZA meeting.
Is that a substitute motion?
He's offering us.
Do we understand that to be offered as a substitute motion?
And the purpose of the deferral is so that more options can be presented for rainwater collection diversion.
And then neighborhood outreach.
Yeah, and neighborhood outreach.
And this is a substitute motion?
Yes.
Because we already have a motion on the table,
Okay.
on the floor.
Yes, that can be a substitute motion.
And specifically, you've got to talk, your client or you have to sit down and talk with the neighbor immediately contiguous at 1034. And this is something that we've required applicants to do in the past, is to meet with those who are adversely affected, who've come and expressed that, taken time out of their day, evening to do that.
I had no idea.
It's not going to fly that they weren't home or they didn't open the door. That's
I just thought
Mr. Chairman.
I thought there was no interest.
So is there a second to the substitute motion? I think the motion fails for want of a second. I have to entertain the motion that's on the floor. Hearing no further discussion, all in favor of the motion proposed by Mr. Owen and seconded by Ms. Freshman to deny the subject use permit due to the reasons given in the motion, signify by saying aye.
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 That means I can't, at all?
All opposed? I'm sorry, the matter, the motion passed, which was in effect denying the applicant's request.
So there's no chance to reapply?
You can appeal.
Mr. Chairman, question to staff. Can this application be resubmitted in the future? Can a similar application be resubmitted in the future?
There's no prohibition from bringing this or a similar application back to the Board of Zoning Appeals.
There are two courses. Appeal the denial or come back with another plan.
And does that mean a resubmission and a new application and everything?
You'll have to.
That's right.
It is?
Resubmit a new plan or appeal this denial to the circuit court. Those are the two courses that are available. Thank you. Thank you all for coming. Mr. Rissy, please call the next case.
Case number V-11493-19-U-1 is a use permit request by Sabir Johnson, the owner, to permit a left side setback of 5 feet to the wall, 4.2 feet to the eave, 2.3 feet to the planter boxes, 2.1 feet to the window well from the left side property line instead of 8 feet to the wall, 5 feet to the eave, planter boxes, and window well as required. To permit a right side setback of 6.7 feet to the wall, 5.8 feet to the eave, 3.9 feet to the planter box, and 3.8 feet to the entry canopy, and 3.1 feet to the entry stairs and stoop from the right side property line instead of 10 feet to the wall, 6 feet to the eave, planter box, entry, stoop, stairs, and canopy as required, and to permit an aggregate setback of 11.7 feet instead of 18 feet as required regarding a new single-family dwelling in the R5 zoning premise known as 937 North Edgewood Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. I'd like you to please note there is quite a bit of substantial material for this case that came in after the application packet was assembled and printed. There are, I believe, 5 letters from the surrounding neighbors.
Mr. Chairman.
Mr. Owen.
I would like to disclose that I am acquainted with one of the next door neighbors, and I do not think that that will affect my objectivity in this case, but I wanted to disclose that for the record.
Thank you very much. Any questions of Mr. Rissy?
Mr. Chairman.
Mr. Owen?
Is the owner of this of the parcel with the application the same or different from the current owner of the house at the corner of Edgewood and 10th Street?
It is the same.
I think that's my question for now.
Thank you. Ms. Malice?
On the disclosure, it says owner trustee. Do you have any information as to what trustee refers to?
The applicant is the trustee of the Sabir S. Johnson Revocable Trust, who is the owner on the deed of the property.
Where did you see that? Was that in here somewhere? No.
It is, I believe, implied by the disclosure statement, but I looked up the deed for the property to find the name of the owner.
And I guess another question, Evergreen Homes, is that the architect in this case?
Yes.
Is that the Evergreen Homes is the architect?
Yes, ma'am.
Okay.
Now, where is a reference to this trust?
Mr. Chairman,
Mr. Owen.
I would just respectfully suggest to Ms. Malice and you that we might have a more efficient discussion if we call the applicant and ask him about the trust.
Sure. but I was just looking for some written indication.
It's on the financial disclosure.
Well, no, it says owner trustee, but not the name of the trust.
Right.
But we'll get to
That's
that.
information we can easily get from the
I
applicant.
don't see it.
Okay.
Good evening.
Welcome.
You all. I'm a resident of Clarendon. I've been in Clarendon.
Who are you?
I'm sorry, Subir Johnson. I live
Your
at
address?
1305 North Herndon Street.
Thank you.
I'm a resident in Clarendon. I've been in Clarendon since 2007, a couple blocks away from this piece of property. I'm a orthopedic surgeon. I'm not a developer. I'm a member of the community. And the circuitous way that this property landed in my possession was that I operated on someone who was a broker who came to me with this property as an investment potential, knowing that I live in Clarendon, et cetera. I've been working in the community I've been in the community since 1982, Northern Virginia, Vienna, local guy. Again, you'd mentioned the trust. I'm the sole trustee. It's in a trust. The trust name is 937 North Edgewood Street. Myself personally, the only trustee. There are no other trustees. There are no other owners of that trust. Just to clarify the earlier
Mr. Chairman.
comment.
Mr. Owen?
May I ask who are the current beneficiaries of the trust?
My family, my
Your
I have
immediate
immediate
family.
family, which is I have 3 children, 7, 6, and 3, and a wife.
Thank you.
Yes, sir. So the idea for this home, which makes no financial sense and makes no sense using my limited amount of time and resources, came out of a conversation with an elementary school teacher at Taylor Elementary who commutes 2.5 hours a day to and from work to teach my daughter, who's now in 2nd grade. Secondary conversation with multiple nurses. So this, in my mind, is ludicrous. So the idea would be on my own, not relying on the county or relying on anyone else, and no other investors, because every investor said, including the bank, the land design people who invest in these things, the builder and the architect, this makes no sense. No financial sense whatsoever. And I'll get into the details. I did it anyway, because our young professionals shouldn't be driving 2.5 hours to and from work to take care of you guys or myself in the hospital, or to take care of our children at school. I feel very strongly about that. So the idea would be to build a house on this small, skinny lot, 25 feet, and the current regulations would allow that house to be 7 or 8 feet wide. So what we've asked for in this application is a little bit wider, and I've made the house shorter to minimize the impact on the community. Now, I live in this community. I'm sensitive to renters in the community. I'm sensitive to the look of the community, the feel of the community, the landscaping, et cetera. And again, I'm a neighbor. I'm not an outside developer. I'm not planning a row house with a party house. So that was the plan for this, the idea for it, the genesis of it, and I've owned the home for a year plus looking to make these plans. Getting on quickly, I didn't want to build a 7-foot wide skinny house that looked horrible when they presented the plans to me. It looked like a trailer on steroids. It detracts from the neighborhood. It detracts from the feel of the neighborhood. Didn't look right to me. Requested the variance figures that you have in front of us, and did a study of have those precedents been set before, and they have been set before, asking for a few feet on each side. But again, I want to emphasize decreasing the rear setback to allow the 2 rear houses an extra 35-foot buffer rather than 25 feet in the development process. What you don't have in front of you is my community outreach, and so I've met all of the adjacent neighbors. I did send an email to the Lion Park Civic Association, did not get a response. The immediate neighbors, they're here tonight. The one directly next to it, which is really the only immediate neighbor on Edgewood, contacted me even prior to me contacting him about possibly developing our properties together, knowing that I had bought the property, looking up the tax records. He's a lawyer. And we met twice, first on August 13th, spoke by phone on August 17th, met again this past Monday, and this Monday he did iterate to me that he would not support the project. And I guess he can come and tell you the reasons why. I've met with the other neighbors, adjacent neighbors, not to elaborate too much, but the two that are adjacent directly in the back, showing them the renderings, brief story, less than now, and making them understand where the house would sit. And lastly, although not an immediate adjacent neighbor, I've not met but spoken to Clayton a couple doors down on North Edgewood as well about the plans. He had seen the BZA application because of the notification on the light poles, on the telephone poles, and we spoke again, detailed why I did it, and also how we came up with the plans. So I understand the neighbors' concerns. They'll voice them themselves. I've heard them, at least some of them. But I would like you all to consider me as a citizen of the community to base these decisions based on the merits of the case, and based on the previous precedents, and based on the fact that I'm trying to help to improve access to either renters, professional renters, or young people that want to buy a single-family home for less than $1.9 million. I don't think that's where Arlington needs to go. That's all I have to say.
Thank you very much. Questions of Mr. Johnson?
Yes, sir.
Dr. Johnson.
There are none yet, but we have a list of speakers, so stand by.
Actually, I do have a question.
You have a question? Go ahead, Mr. Owen.
There's a giant tree in the back of this lot.
Yes, sir.
What's its proposed fate?
It's preserved on the initial plan. However, over the last 6 weeks, that tree did not look very good, meaning I'm not an arborist. I've had only someone that mows the lawn that actually works for the county say that has to come down, but the current plan, the 35-foot setback, preserves that tree. Whether it will be preserved because it won't live, I don't know.
Thank you.
Yes, sir.
Okay. Now, you heard me describe the problem with our counter not being activated tonight. So,
Staff time.
yeah, we're going to try to do it in a manual way. And I hope that I'll call two names. I'll let them know. I'll let you know who's second up. If someone has already said what you want to say, just merely say, I concur. Try to cover new ground if you're going to come up. But we welcome your participation. First, Jessica Petrone, 934 North Daniel. Welcome. Following her will be Demetrios Kambolias.
He's my husband, so he will inevitably echo everything I have said.
Oh, I'm glad I called you first. Thank you.
Well, thank you for giving us the opportunity to be here. I will admit I was hoping I didn't have to go first, so I'm a little nervous, but I'll try to summarize some of the concerns that the group of neighbors here have, and hopefully everyone will touch on a few different issues, so you'll hear fully vetted all of the concerns we have about this proposal. First and foremost, I think I echo on behalf of all the neighbors the fact that we apologize for having to raise these concerns verbally tonight. We would have submitted concerns in writing if the full information on this proposal had been made available sooner. It was only this weekend that we discovered the sort of full nature of the variance that was requested. Originally, when we received the notice from the county, we thought this would be a renovation to a vacant property that has been sort of allowed to fall into some disrepair. And we were excited about a new owner coming in and renovating, rehabbing the property, and that was good news to us. But then the full details emerged, and as you can see from the images, the owner is proposing to divide one parcel into two separate lots, both of which will occupy a tremendous amount of the square footage on the lot. So we have some concerns about the precedent that it would set, allowing units that are composed of multiple lots. As I understand it, there are at least 9 on the Edgewood block alone, let alone the related Daniel Street and Highland blocks. So the ability to convert a multi-parcel lot into, several 6+ bedroom houses on a short block that runs from 10th Street to Washington Boulevard would almost triple the number of occupants on that one block. Further, there's some parking concerns. The plan indicates that there'll be a double parking or a driveway that's made available, but that sounds like it will only fit 2 cars, and he's proposing to have a 6-bedroom professional renter house. Okay.
Okay.
Thank you.
Thank you very much. Thank you. Demetrios Kombolius, you can finish up, complete that presentation. Following Demetrius will be Aaron Niesenson.
Thank you very much for all your time and the opportunity to offer comment. My wife did, in fact, hit over very many of the high points that I was going to hit on. We certainly, with the public notice, exactly as she said, we looked at the little drawing on the back and thought, okay, it's a modification of the existing house. So we would have offered comment sooner and appreciate however, the opportunity to offer comment now. We certainly agree that between the two of us that this proposed house, as staff mentioned in their report, doesn't have an analog in the neighborhood. And so I think with that, I will, I guess, yield the rest of my time to the other speakers. My wife hit all the other points that I was going to make. Thank you very much.
Yep, thank you very much. Perfect. After Mr. Niesenson, Aaron Duffy, I have to confess something akin to Mr. Owen. I was actually in charge of an organization about 25 years ago, and Mr. Niesenson was the lawyer for that entity.
Oh my gosh!
That was AFSCME many years ago. I later became
Good to see ya.
its lawyer. So.
Oh my gosh!
Anyway, welcome.
Wow. All right. Well, I'm just stunned here for a second, but let me recover.
No, that was 25 years ago.
Yeah,
Oh.
that's incredible. That's great. Well, maybe we can catch up soon.
Yeah.
Let me just. There's so much to say, and let me just try and go through it quickly. And pardon me if I'm speaking too quickly. But there is not a separate lot here. There is only one lot. That is a house with a driveway next to it. There is no lot there. I have all the documents. I can give them to you. You can look them on the county website. The back of the notice only has one lot. This is a description of a lot. The GIS is one lot, 937. The property card, which I have copies of, is one lot. It's 937. There is no lot 171. There is just that house, a driveway, and a little room on the side, and that's it. And the other examples that are given in the report on width of houses, every single one of those involved a pre-existing lot that had been there since the 80s, probably more like the 50s or the 30s, okay? They were pre-existing lots identified by the county. This, where he's putting this, planning to put this, desiring to put this, is not a lot recognized by the county. It's part of his property. It's not separate. And so his application says it's for lot 171. 171 doesn't exist on the county records. When the notice went out, it doesn't say lot 171. It says 937 North Daniel, because that's the only lot that exists. He would like for there to be a lot there, but there isn't. Okay? And then think about what he wants to put there. He wants to put a 3-story house with 6 bedrooms. The entrance is on the side, and the stairs are 3 feet from the property line. It's virtually a townhouse. Now, under his logic, everybody who has a lot and says a lot designated here on the county, I'd be able to split my property in 2 and put up 2 houses with another 6 bedrooms each, okay? And then a couple real quick things. I think that the other thing is this applies to every lot in Moore's Addition. Everybody could do it because he's saying a lot is what we call our properties. Mine is 171. I'll give you the documents here. I think the other thing is I don't think that this is proper for a use permit. What he's asking is for you either to subdivide the property because there is no other lot, or to put two houses on one piece of property. And I don't think you can do either one of those things. And that's all there is. I'll give you these documents. I just have one. I have one copy for him, one copy for the board, I guess one for the record.
Thank
But this is, what I'm giving to you is the demonstration that there is no Lot 171. There's only 937 North Edgewood. I also have on here at the back of it, so I have the property GIS record. I've got the card that shows the, what do you call it, property card. I've got the printouts from this. And then I've got my own, which shown that mine is made up of two lots. So therefore, I could theoretically split mine, as could everybody in Moore's Edition. I'll give you these and then.
Okay. Thank you very much.
You can give it to staff.
Here, hold it. No, I'll take it.
Well,
Let's see.
could I just ask a question of staff while you're?
We're going to, yeah. We're going to flesh that out because that's
this
the
a
opposite to what we
subdivision
have.
document? Is there a subdivision document in our package?
Not a proposed subdivision. I believe that is a
An
subdivision document from 1920.
This is a document that shows that this parcel is subdivided.
The original subdivision, yes.
There was an original, 1910, all of these lots were 25 feet or whatever wide they are, and then they built the houses. Mine was built in 1913. And since that time, since the time the houses were built, they're all identified lots that are separate, that are, they might be two widths wide, but when I bought my house, I didn't buy two lots. He didn't buy three lots, he bought one lot.
Just for staff, this is a subdivision document that we're looking at.
You're referring
From October 1910, yes.
What are you referring to?
In our packet, the last
Okay.
item is a subdivision document from 1910.
It is, I believe, deed book 126, page 192, as labeled in the upper corner.
Yep.
Right. So just as reference, we were shown a subdivision document.
There is, and the staff reports are down there. Take a look at the staff report, the next to the last page. This is a 11493 is this case. Do you see that listed at the top in the heading? There's only one for each. Go down that list, 11493. And yeah. There you go, Mr. Niesenson.
Take a, just
Take
for
a
your
look at the last
reference,
two pages.
and we'll get back on this point. Not now.
Not now.
We
We're
got
going to
another
Ms.
speaker.
Duffy now. Thank you very much.
Okay, I would just say that I did look at it, and that's in my letter. I don't know if you got my letter. I put in a letter of
We
opposition.
do. That
I
was
said
received.
that there are 9 houses and 9 lots if you look at the county website on just that one side of Daniel Street. If you look at the 1910 document, there are 21 lots. Those are not the lots for the houses that we live in. Those were the lots that were there for maybe 2 years. My house was built in 1913. I'm not claiming I have 2 lots.
We're beyond the time limit. I appreciate that. This is very helpful. Ann Duffy and then Clayton Swope.
Good evening, and thank you for sticking with us at 11:30 p.m.
Vice versa.
So I'm going to quote a couple things I just heard from Mr. Johnson. Limited resources? I think not. Community outreach? I think not. Paints this as a labor of love? I think not. I'm not sure what a teacher who makes her own choices to bear the commute has to do with any of us here and neighborhood. Mr. Johnson talks about legacy. I am legacy. I went to grade school. I went to kindergarten at Long Branch. This is my childhood home. I set the home that Clayton, who you will hear from, the previous owners, I set their lawn on fire in the 80s from some fireworks. So if we talk about legacy and we talk about the character of Lyon Park, because that's where we live, it's my home, it's their home, and we want to keep the character of Lyon Park. And
I've seen a lot of changes being an Arlington resident, some good, some bad, better and worse. And the worst is, in the worst category, does go with this aesthetically unpleasing home that he's proposing. And, if it becomes a rental, this proposed skinny house, will the tenants be caring for it like homeowners do? No, they won't. So I request that you deny, both today and in perpetuity, the application and/or variance for these numbers, or anything of its like from Mr. Johnson, who it seems is unfamiliar with the phrase that all politics is local. And he didn't check with us first, and that's just the starting point. So I strenuously oppose this variance.
Thank you very much. Next, Clayton Swope of 927 Edgewood. That was Ann Duffy of 926 Edgewood. Welcome, Mr. Swope.
Thank you. And I do want to upfront thank Dr. Joson for talking with me on the phone, and appreciate the outreach today and on Monday on that. I just want to start out by saying it sounds like a lot of what you're hearing is just a frustration, I think, with a lot of us in the immediate area, just the lack of engagement prior to the last few days on this. I think it just shows you that people are really active in the community, and they really care about what the area looks like and making sure that the developments are compatible with what we've grown to expect in the Clarendon area. So I think that's one thing that I've just observed just sitting here and being the last to speak. I think that the second thing, and I think we all kind of cued on this, just hearing the plan, is that it's probably going to be a rental. It's got 6 bedrooms and 6 baths. I think we're kind of worried how that would fit in with an area where there's already a lot of concerns about street parking, and that since in Arlington code, I know you're only supposed to have 4 unrelated folks living in an apartment or family, and this just seems set up to kind of already violate that and kind of flouts that that piece of the code. And then third, I think it's just we all are still a little confused about what this would mean and what the precedent is for a structure like this in Arlington. We look at the similar properties in the application, and though there are some similarities, there are ones that aren't. And I think Aaron raises good points about a lot of those involve tax parcels that have been taxed separately for a long time, not a situation where you broke a tax parcel into separate lots from plats from 1910. So I think we just would have liked more time to think about that, to talk about that with the applicant, and just have a chance to really see if there's a way that we can get to maybe something that everyone's happy with and not just feel kind of rushed. So I think what I was asking for was just maybe some way to defer this so we can have those discussions. But I know a lot of folks that are my neighbors just want it outright refused. But it just seems like, at least at a minimum, we could have a chance to discuss it with the applicant. Thank you.
Thank you.
Thank you. Last speaker who has signed up is Christopher Zeller of 938 North Daniel.
Hi, thanks for your time. So I also want to thank Dr. Joson for stopping by on Monday. Agree with my neighbors that we kind of got the gist of this program delivered to us only within the last few days. So my wife has written a letter to ask for more time, for a deferral. And I was on the same wavelength until I slept on it last night. And frankly, using Dr. Joson's own experts that he consulted, I tend to agree with them. This is a proposal that just doesn't make a lot of sense. It's not in fitting with the character. At this point, I would echo what my neighbors have said. It's not in fitting with the character of the neighborhood and the street. If we're going to address the chronic problem of housing shortages in Arlington, there are pre-existing quasi-governmental ways to do that. The Arlington Affordable Housing Commission, other means to address that I think are a lot more effective. That said, I'm not impugning Dr. Joson's integrity at all, and I do appreciate him stopping by. But putting a 3-story skinny house behind mine in my view shed just doesn't make a lot of sense. And we do need to figure out the disposition of that tree sooner than later before it crashes in on one of our houses. So that's all. Thanks.
Sorry, sir. Would you mind just repeating what you said about the tree?
We need to figure out the disposition of that very large, I think it's a white oak or a pin oak, behind the gentleman's property. It has turned brown prematurely. So a lot of trees have this year. I don't know if that's a function of the flooding and then the dry conditions we have, but
I see.
it's in
It
it's
looks to you to be
seemingly demise
I see.
condition, but
Okay. Thank you.
I'm not an arborist.
Mr. Chairman?
That was the last speaker, Ms. Malice.
So one of the things that we heard from the speakers was sort of the lack of realization about what 937, where 937 North Edgewood is. In other words, when they saw the notice, they assumed it was the house that was under consideration and not the lot. I mean, this is kind of procedural, but how would they have figured out that this was something different?
I think that probably the only way to figure out would be to look at the application.
Yeah.
The notice did mention a new structure, but beyond that, it really was just in the application. Unfortunately, we only have one address to advertise with.
Yeah, that I think that kind of what is what it is. It certainly wasn't intended to conceal anything. It just was the way that this application was.
Or kind of a deficiency in the notices that are given to neighbors. Maybe the notice should include a map showing and maybe a partial description of the application or a part of the.
Well, the full application has been on the BZA's website for 3 weeks.
But again, it was advertised as 937. And so that would lead a reasonable person to conclude that's the house on the corner that they're talking about, and not what was described by one speaker as a driveway.
Yep.
Which they would think, well, no one's building a house there. But
But all these drawings were available about 3 weeks ago on the BZA's website.
So, first question for staff: when would the community have gotten letters on this?
The neighbors may actually be better able to answer when they
or-
received their
or-
letters, but
2
it
weeks
was
ago? And you got, okay. So Mr. Owen's point is that, somebody could have read the application and maybe figured it out.
Or gone and looked up the application to look at the details of it at that point.
Yeah, what wouldn't be there was the staff report. The staff report just went up a few days ago.
Okay.
Right.
But
It's
the
just that
application,
caption. It's what the public notice is.
yes.
But
It is very
no. What was on nowadays, recently,
Yes.
starting this calendar year,
Right.
it's
the
not
full-
just the caption.
It's the
The
full.
complete text of the application and some supporting materials typically are put up 2 weeks before the staff report even goes up as a link.
More than the public notice?
Much more than the public notice, pages and pages of material.
Oh, okay.
No.
No, but
Not now.
off record, do it in an email to the county. Okay.
All right, so I guess that unfortunately falls on the fallout falls on the applicant for that one, but it really is not the applicant's. I don't think it was his intention to mislead anybody in this situation.
Well, I mean, it goes to the applicant's outreach. Now, that was the notice. What did the applicant do and when did he do it in terms of outreach to the neighborhood?
Well, I can reiterate that, what I said before. The immediate neighbor, Aaron, I met with on August 13th, spoke with him again on the phone on August 17th, and again this past week we met.
So the 13th is when you made...
August 13th, yeah, August.
I beg your pardon?
August 13th, sir.
Oh, August 13th.
Yes,
You went
sir.
door to door
No, we met in his home. I sat in his home on August 3rd.
with...
The immediate neighbor on 937 North Edgewood.
Okay, so there were a number of neighbors at this meeting.
No, there's just one neighbor, just myself and Aaron at that meeting.
Okay. All right.
So, I think that Mr. Chairman, one of the basic questions is, how strongly does the county feel that the applicant has a right to develop this parcel?
Well, the county believes he has a right.
We wouldn't have brought
They
it
say it's
to you.
buildable.
It's buildable.
And our issue, and the issue with us is, are we going to grant some relief from the strict application of the ordinance with respect to the setbacks?
Mr. Chairman?
Mr. Owen?
The county staff at my request has pulled up a zoning map, and I was just curious if you could scroll to show a little bit to the south of this area so that we can see where the transition from R5 to R6 is. So at some point, we get into Lion Park R6 to the south. I just want to see how deep that is.
And excuse me if I may, this house exists on North Barton, 3 blocks away. Same house.
Later, I'll want to do that too, but really, all that's R5? I thought it was all R6. No, there we go. R6. So R6 is on the other side of Washington Boulevard. Interesting. Okay, and now if you guys could zoom back in to the middle of like just above the mouse pointer there, just a few houses above the mouse pointer. If you could zoom in a little bit.
Where do you want them to go?
Zoom in. No, above onto Danville Street, but Danville between 9th and 10th. You got the right map up there. It's working out. I saw what I needed to see.
Okay.
Now, just stop. If you see where it labeled North Danville Street, there's the ST. It appears to me that there's similar skinny houses there, right? And then if you go over to Barton Street, it looks like there's some similar skinny houses. And while we're on Barton Street, let's scroll down a block or two on Barton. Almost to Pershing. A little bit farther. Okay, stop. Right there, right where the mouse pointer is, to the right. I believe right near there's a house that I think is 10 feet wide.
11.
11 feet wide.
That's the Mickey Simpson house.
Yep.
Yes, sir.
Yeah. Oh, yeah, I was. We denied that. We denied, and that's right. And he said and he built. A 3-story house.
So I don't think it's like the most outrageous concept ever.
But he didn't put 6 bedrooms in that.
I'm not saying that I'm ready to support this application. I'm just saying that the basic notion that in this neighborhood, there would be in R5, which has characteristics different from R6. The basic notion that there would be an exploration of a skinny house on a lot like this, it's not outrageous.
No, it's not. I agree. It's not outrageous. It's the, I think it's the number of individual bathrooms and bedrooms. That is what.
That's not
it doesn't make it outrageous. It makes it. I think the compatibility with the neighborhood becomes an issue then. 4, as one of the, because I think the county ordinance does say in terms of a rental that you can't have related adults more than 4.
Yep.
But you could put a whole family in there. I mean, you could have cousins, first cousins, I think.
If I may, my intention is not to put 6 people in this home. That's not. I would not break the law. I live 7 blocks away. I have a much bigger reputation to uphold than to make money off a rental and illegally.
Okay, but
in Virginia.
But the trust sells it after it's built.
Exactly.
Mr. Chairman.
And, I'm sorry, go ahead.
If I could.
Go ahead, Mr. Owen.
In Virginia, there's severe limitations on our legal power to consider whether it's rental or ownership and what kind of people will live there.
Oh, that's
also
true.
Federal housing concerns. I mean, we usually don't venture into the house to find out what's going on.
Except this applicant has made a reference on the record as to what his purpose is and how he intends to. You heard the story as far-fetched as. I like Mr. Swope's, I think, reply. It is a bad idea, but
It's just dangerous territory for us to be.
No, you wouldn't rule on that, but compatibility with the neighborhood.
As described in the zoning ordinance.
I think there's an issue, but.
I think it's pretty clear a deferral is the right thing here,
Sure.
basically, is what I'm saying, right? A denial seems, I think, we're dealing with someone who's trying to work without as many professionals as some people do. He's put in a very thorough application. Now the neighbors are engaged, a conversation can happen. If the neighbors want to make, I think they can file for a zoning administrator determination on their question of what's a buildable lot.
Sure.
That's one way to resolve this.
It's buildable.
I don't know that there's been a formal zoning administrator determination on that, has there?
There hasn't been a determination, but I do want to clarify that those who are not the owner of the property cannot apply for a determination on a property they do not own.
Maybe. I think I remember it happening.
Mr. Chair?
Mr. Melnick.
Okay, so the way I'm looking at this is, and I appreciate the neighborhood wanting input, but it does seem to me that, what the complaints are is aesthetic, and whether it's going to be rental or owned, and things that we, like Mr. Owen said, we don't usually venture into. And it's my understanding it's a buildable lot. It is a lot. It seems to comply. It was in existence, when the zoning ordinance was adopted. But so just on that basis, I'd be inclined to approve, to make a motion to approve it at this point, just because I don't know what can be gained out of meetings if the sorts of complaints that we've heard tonight are brought up. Whether he's going to rent it or not, or that kind of thing.
Well, we, as you would understand, you really can't shout things out from the audience. We did hear from each one of you, and we're seriously considering everything that was said. And the expression of one member is, you'll hear members along the dais describe their feelings of the application. Ms. Freshman, sorry.
Well, I think Mr. Owen has been very helpful in pulling up this map and showing us this neighborhood has a wide variety of interesting structures of all ages and sizes. I'm inclined to support the application. However, I would really like it to be 2 stories. I think if it were 4 bedrooms, it would still be very much appropriate for the market. It would be much less intrusive. I've seen plenty of skinny houses. There's one, a blue one, on Washington Boulevard, not far from here, from this site. I can't understand why they haven't finished the front concrete, but it's ugly.
I know the home.
But anyway, there's a lot of interesting and eclectic architecture, and particularly because it's an R5 zoning that allows for multi-family and other things. I'd rather see it lower. I think it would be much more compatible with the neighborhood, but I don't object to a house being on that lot.
Well, the height issue, it's 31, and that's under. We don't have anything to say about that.
No, we do if it requires a use permit.
Right now.
Well, true.
County staff has previously made recommendations based on the height of something and saying that nothing this tall has been placed this close to the street before. Height has been considered in that context in staff recommendations before. So I think it's fair play in a use permit application.
Just because the application's before, so
It would have to be deferred to be revisited.
Yeah.
Yeah, we're not going to change that.
And it would be, I would really love to have more development of the buildability of the lot issue, something that we're not looking at 100-year-old subdivision records and whatever, but a memo from the zoning administrator or somebody who has the right to do so, getting something in writing from the zoning administrator that spells this out, or the county attorney, or someone's attorney, like, I'd love to have that be, if that's an issue that people want to raise, it just be.
Mr. Owen?
Yeah.
Go
Mr.
ahead,
Chairman.
Ms. Malice.
Did I hear one of the speakers say that there were many other properties like this that had the same condition that were subdivided already?
Well, like Mr. Neesonson, he said his property is really 2 lots, but there's only 1 house sitting there, and that there are others like that. This is one address, 937, but there are 3 lots that comprise.
I think Mr. Neeson's argument is, if this is buildable, he says, then all the rest of these tiny little
That
lots
are like that.
could each have their own tall, skinny house on
Yeah.
it. And he suspects that that might not be the case. And I don't really feel like I have the.
Well, that's where I was going, was I think we need some clarity on not just this property, but the entire neighborhood in terms of buildability.
How many vacant lots are there that are
Well,
narrow?
even if they're not
in that
vacant, if somebody tears the main house down.
Yeah.
and they
Okay,
can
yeah,
build-
yeah, or how many lots that have, how many lots are there that are, how many houses are there in this area where that sit on more than 1 lot? That occupy,
Yeah, well, in any case. you
So
know,
they appear as 1 lot, but they may in fact not be 1
Right.
lot.
Exactly, and one
And
one
if they
could be
were
torn-
vacant,
They could, 2 could, so it's just, I think this is when we venture into a neighborhood with something that hasn't been recognized before, we want to see the larger impact of, approving this, which could be precedential if, or at least it's not setting a precedent legally, it's just giving other people ideas that, hey, I could do this on my property too. And before we go there, we want to make sure that we really got everything covered here.
there is a tiny house movement.
also there's an affordable housing
Yeah.
issue in Arlington. And, at some point, some of the zoning issues are going to have to be revisited.
If I may, I'm very sincere in my arguments. I want everyone to know that this makes no financial sense. This rental, the numbers make no sense. But it doesn't matter. There are lots of things that do not have to make financial sense. The precedent has already been set. North Barton, that house, is this house. I've taken 10 feet off of the back. The architects consulted, and that is what this is. This already exists. I'm not here to upset the neighbors. I live here. I've upset them. So, in the end, that's concerning to me as well.
Sure.
And I think that animosity and tension. I'm a tension resolver. That's what I do in life. However, we do have to push the envelope. The county's not doing it. Someone has to step up and say who is going to sell this home to a single family. Whether it's 6 bedrooms or it's a 4-person house, whether there's a big basement in the bottom or not. I don't think that's for us to discuss. But it's an affordable house, either whether it's a rental or $1 million, $900,000 sale. This is an affordable house in an unaffordable area walking to Metro in Clarendon.
Mr. Chairman?
Go ahead, Mr. Malice.
Just a question on staff based on that. This site, if 1937 were torn down, could a very large house be built on both lots?
Yes.
All 3 lots.
Up to the allowances provided for coverage in the R5 zoning district.
Yeah, so your other option is to tear
Build a
everything down.
McMansion.
And
That's
build a McMansion on the corner. In terms of, it may not suit your purpose, but, that would be a probably more financially rewarding option.
Well, more financially rewarding to myself and the neighbors. I've heard, I didn't bring it up, but maybe we should discuss it. The sentiment is that this is going to devalue the other homes around this home. And I've heard it from two of the neighbors. Not
So,
picking on
yeah,
you.
I'm a longtime planning commissioner. The devaluing question, is never.
It's a very sensitive issue,
Never
and I understand
happened.
it.
Not that
It will not.
Not-
It will not.
No neighborhood has been devalued by construction.
Well, individual homes sure can be. There are in the Clarendon area, I can walk you by some homes where the individual properties were not as valuable as a result of the adjacent development, even though the neighborhood as a whole may have been enriched. Individual neighbors can absolutely be disadvantaged.
No, I'll take your point.
So my view is I wouldn't be able to approve this tonight because I don't know the fate of the tree. For that alone, I would want a deferral. I'm not sure that the financial disclosure was complete. I don't think all the people with beneficial interests were listed on the financial disclosure. For that reason alone, I would be interested in a deferral. Those are the two most obvious. I really, once those two things were in play for me, I have to admit I didn't, we just spent like an hour on some sheds next to a house. Like I have not applied that level of analysis to this parcel, and it sure as heck deserves it.
Sure.
So I welcome the opportunity that a deferral would also allow that kind of analysis. And as long as we're deferring for all of those reasons, it would be spectacular if there would be more discussions between the applicant and the neighbors to see if something can be worked out. And for the Civic Association to have a debate about how they feel about the possibility of all these properties being redeveloped, and potentially to get more guidance from whoever in the county could give us more guidance about the legalities involved. So I think there's a lot of benefits to deferral, even though I'm, sort of leaning yes to something like this, even if it's not exactly this. There's no way I'm approving it tonight, and I also would feel it's a shame to vote for denial tonight. So that, to me, it's like the strongest possible case for deferral.
Mr. Chairman.
Ms. Malice.
In regard to the tree, Mr. Owen, are you looking for some kind of certification from an arborist?
Yes.
In terms of what?
The opinion of a
its
certified arborist as to its condition and what would be necessary to preserve it if that were feasible, whether or not the development does preserve it. You were here for the discussion before where the applicant really wanted to preserve the tree, and that was driving the entire issue. And
Yes,
so
sir.
then we talked about like what can we put in the application that would in fact preserve the tree. So if you happen to know a lawyer, you could talk to them about the same issue as well, or you could contact them and maybe you could hire the lawyer together for the same purpose.
Or if the tree is not, viable.
The arborist says the tree
That's
is
my concern.
already-
That
If the tree is not viable,
Doesn't
we
sound
need to
viable.
know that too.
Yeah.
I think a neighbor indicated that it was.
multiple neighbors are worried that the tree might fall on their home, and I looking at it, I agree. I'm not a certified arborist. I get it.
Right, but that's a simple step. And I think that I would encourage the neighbors to engage with whatever the application looks like the next time around, to provide us with super specific information about the details, right? Like, what do you think about the left-hand side? What do you think about the right-hand side that's being proposed? Because if a majority of us decide not to go on full-on denial for the existential reasons that some of you raised, then we would love still to have your advice about some of those minutiae. And that's not prejudging it, I think there's still I don't know how this is going to go. I have no idea where the votes are or where the votes would be after a deferral. Maybe there would be further clarification. But I could see this being approved, denied. I think it depends on what we learn.
Yeah, I think we just need some more facts. And if you're willing to accept a deferral for a couple of months, that's probably where we would go.
And I think seriously consider also Ms. Freshman's suggestion of whether or not you would still be interested in moving forward if it were a story shorter.
That's for you to consider.
Let me
You don't have
entertain.
to answer
Are there
now.
any motions?
Mr. Chairman, I'd be happy to make a motion in the matter of V-11493-19-UP-1. I move that the Board of Zoning Appeals defer the matter to our November hearing.
Is there a second?
Second.
Thanks. It's been moved by Ms. Malice, seconded by Ms. Freshman to defer this matter to the November meeting of the Board of Zoning Appeals. Any further discussion of the motion?
Does anybody need clarification on what we're looking for? I think we've talked about wanting information from staff, some consideration of heights from you, the neighbors in terms of, what specifics they might want to add to this project. Just want to make sure that in the next 2 months, everybody knows kind of where we're headed. Okay?
All right. Hearing no further discussion, all in favor of the motion signify by saying aye.
Aye.
Aye. All opposed? The ayes have it. This matter is deferred. Good luck. And
Mr.
Thank you.
look
Good
forward
evening.
to seeing you all again in a couple of months.
Mr. Chairman,
Rowan.
the next two items relate to the same parcel, and I just want to let you know that I'm prepared to move their approval with no hearing if the applicant is willing to waive the hearing.
Let's, these are this is the childcare facility,
Yes.
the three houses on.
So we're
Yep.
we've moved, and so
Okay,
we're done.
let's call that those next two. I think there's a variance and a use permit associated, correct? So let's call the variance first, and then call the use permit at the same time. Thank you.
Case number V-11494-19-VA-2
Thank you all for coming, by the
is a
way.
variance request by Medita Realty LLC. The owner to permit a separation of 14.6 feet instead of 15 feet as previously approved by the BZA between buildings number 1026 and building number 1022 regarding a new Montessori school and existing buildings in the R5 and C2 zoning districts on the premise known as 1022 South Highland Street. Staff recommends the board adopt the attached resolution granting the variance request. Case number V-11494-19-UP-2 is a use permit request by Medita Realty LLC. The owners to permit a separation of 14.8 feet instead of 15 feet as previously approved by the BZA between building number 1030 and building number 1026 regarding a new Montessori school and existing buildings in the R5 zoning district premise known as 1022 South Highland Street. Staff recommends the board adopt the attached resolution approving the use permit request with conditions.
Mr. Chairman?
Thank you very much. Mr. Owen?
Again, if the applicant's willing to waive the hearings, I'm prepared to make a motion from both items.
Let me explain. We're very familiar with this. We remember the discussion, and this isn't. This is technical in nature, and it's so if you're willing to trust us, then I will allow Mr. Owen to make a motion now, and I presume it's going to be the kind that we can all support.
Mr. Chairman,
Mr. Owen.
in case V-11494-19-VA-2 and in case V-11494-19-UP2, I move in a single resolution that we grant, in a single motion, that we grant both resolutions as recommended in their respective staff reports.
Second.
Thank you very moved by Mr. Owen, seconded by Ms. Freshman, and I presume that's for the reasons that are described in each of the staff reports.
Yes, and in their respective resolutions, which I move the adoption of.
Thank you very much. Any further discussion of the motion to grant the variance and the use permit? Hearing none. All in favor of the motion signify by saying aye.
Aye.
Aye. All, any nays? Hearing none. The matter is granted. The matters are granted, and please, Mr. Rissy, let the minutes reflect that these were both passed and viewed individually, but passed collectively.
Understood.
Thank you very much.
Thank you very much. Thank you for your patience.
You guys for staying so.
I know it's worth it. And now the last case.
Case number V-11495-19-UP-1 is a use permit request by Christopher and Catherine Pickens. The owners to permit a street setback of 18.8 feet to the attached stormwater planter box instead of 21 feet is required from the North Kennedy Street right-of-way, and to permit a left side setback of 4.7 feet to the attached stormwater planter box instead of 5 feet is required regarding a after-the-fact approval for the placement of an attached stormwater planter in the R6 zoning district on the premise known as 2021 North Kentucky Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions of Mr. Rissy?
Really?
Christopher and Catherine Pickens before us. Welcome. Thank you for staying so long.
Good morning, Mr. Chairman.
Good morning.
Don't remind us.
Any questions of, well, let's ask, do you have anything to add that the staff report hasn't covered?
The only thing I would note, just one clarification is that my wife and I have owned this property for 10 years, so it's a new house, but we're not new to the neighborhood or to the property, and that we submitted a revised survey. So the original survey said that we were 3/10 of a foot too close on the side setback. We had it resurveyed, and it turns out we're fine. That's actually 5 feet. So the application requests that the approval to be closer than the 5-foot setback, but we don't actually need that. We had it resurveyed, and that survey is in the materials, the revised survey. With that, I'm happy to answer any questions you have. I know it's late, so I won't.
So your application is only for the 18.8 feet to the front, is that right?
I believe we had a revised survey that's submitted that shows, it's the second to last page of the report, that shows that it is in fact
5 feet.
It does satisfy 5 feet in that front left corner. So all we need is the approval for the 21-foot setback.
So what's the consequence of our approving 4.7?
They're within it.
They could expand.
You could build
You
it
could
a little
expand.
bit bigger.
You could put slate on it.
I would say,
Thick slate.
given that they stayed past midnight, I'm going to give them the extra
I think I will too.
3/10 of a foot. Mr.
Any further
Chairman,
discussion?
We're getting crazy.
Any questions of the applicant? Any further discussion? I'd be happy to entertain a motion.
in case V-11495-19-UP-1, I move the approval of the resolution as granting the use permit request with conditions as described in the staff report.
Thank you, Mr. Owen. It's been seconded by Ms. Freshman, moved by Mr. Owen that we approve the use permit. All in favor of the motion signify by saying aye.
Aye.
Aye. All opposed? The ayes have it. The matter is
And
approved. Thank you very
Mr.
much.
Chairman, I just again thank the applicants for their patience. We usually end a few hours before this, and it was unexpected for us as it was for you. that we
No
went
problem.
this
We
late.
appreciate your consideration. Thank you very much.
As long as it works.
And minutes before us.
I move approval of the minutes of July 24, 2019.
Second?
It's been moved by Ms. Freshman, seconded by Ms. Malice to approve the minutes. Any further discussion?
Mr. Chairman, I just want to thank the staff for staying late too.
Yes. All in favor of the minutes signify by saying aye.
Aye.
All opposed? The ayes have it. The minutes are adopted.
And thank you for the letter, the notice of applicant.
Can I speak to that before everybody runs away?
Yep.
So I have two comments. One is editorial. You know, in terms of voice,
Thank you.
and I haven't read the other materials to know if this is consistent. You know, the degree to which this should be colloquial versus formal. And I'm, you know, we can help with editing and we can certainly help with voice, but, you know, we use the words like signatory. You know, that's more formal. And so the question is among us, do we want to be more colloquial in this, or do we want to be more legalistic when we talk about this? So this might be kind of both in here a little bit, and I don't know if staff has a preference or feel that we should be more legalistic, or we can say, you have no opinion.
This is the
What
board's
is your,
letter.
your view of this now? Is it too colloquial?
No,
or is it?
it's kind of a both. I mean, it's not consistent in terms of voice.
Mr. Chairman, I would just say there's a concept in government called plain language writing.
Yeah.
And I agree with Ms. Malice that this could use a review for plain language
Yeah,
writing.
and we're glad to do it.
So that would
internally.
be-
But I didn't see it as bad, though. I didn't see it as being like a regulation. It didn't read like a regulation so much as a notice. It was a bit, but I guess I
Well,
couldn't.
basically the challenge is that legalistic writing tends to be briefer. It tends to use fewer, more precise words.
Like
And
signatory.
plain language writing, instead of using a word like signature,
Yeah.
you have to say the person who is signing the petitions that you're passing out, right?
Yeah.
And so that's longer.
Right.
And, you know, so there's a little bit of balancing there.
So anyway, it was just, I was opening that up for voice, not just for this document, but consistency with other documents that we put up there.
And I had some other proposed thoughts when I reread it after not looking at it for 2 weeks.
Yeah.
That the core request is implied but not stated, which is that we expect you to provide their written comments as part of your submission.
Right.
And the words "we expect you" is not there. It's implied by.
But it says to have an opportunity to provide information. It's passive. It should really could be more direct.
We're not giving them a choice.
Right.
Right.
Yeah.
So I think that I would say that perhaps, unless Mr. Rissy wants to further, I think we all would love for you to continue to engage in
But we're
further
happy
revisions
to-
of this document, but we can also
Kick this around among ourselves.
review it amongst ourselves.
But start passing this out. Give this to everybody right now as it
No,
is.
no.
Well, yeah, you got to give them something. We give them some. It can be revised for voice, for editorial, but you want to get.
So you wanted to deem this version 1.
Yeah,
It gets
yeah.
passed out this month, and version 2 will start getting passed out next month.
No, yeah, and it's going to look the same. I
there's
mean,
nothing
version
wrong
1 folk, they're not going to see version 2.
Okay.
Right. So
Yes.
Something, anything Todd Rundgren said.
Speak.
I will give the staff opinion on it. This is your letter. I am happy to take any revisions you have, but I would like everyone to give it their support before we start passing it out. If there are edits to be made, I would rather them be made before we start handing it out. So
I
that
have no objection to this going out,
If
but
you-
it's not what I would.
if you guys all want this to start going out, please direct me to do that
I would
here.
like for this to begin going out immediately to the next applicant who comes in the door.
How-
And that future, and just like the website has been revised over and over and over. I mean, I think that, revisions can be made as we deem them. If someone wants to put their pen to it, fine.
Yeah, I think, Stephen, where we're at is, I think there's 5 votes for starting to pass this out in this exact language immediately.
Okay.
But we also intend to revise it to make it even better a month from now.
Okay.
And so if it's okay for you to stick a different document in the copy you're starting a month from now, but use this one for the next month,
I have a second
I think that's what we
point.
would want to do. Is
If
that okay with you?
that is the direction of the board, we will,
Okay.
by all means.
Go ahead, Ms. Malice.
So my second point is, what's our thinking on the what do you call it, mirror document that's geared towards neighbors, an interesting part. In other words, if you are a neighbor, what do you expect? That the applicant's going to contact you, that you're going to see signs on the street, that you're going to see advertisements maybe in a newspaper. And if those things happen, then what do you do? And so I just wonder at what.
I get it.
So I had a case where somebody got an application, one of these notices in the mail. They had no idea what to do about it.
You mean it doesn't include any explanation? Oh, okay.
Of,
I
we
think
should
that's
write a
helpful. I
letter
think that's
to
a
the-
good idea to have something
goes with the
for
mailing.
those who come
Okay.
Yeah.
to
That they could
engage.
submit written testimony, that they should expect to see plans, that they should,
Expect for it to take a long time, perhaps.
I think step 1 on that is to
Until
ask
midnight.
Stephen to send us a copy of what does go out.
Yeah,
And we can all take a look at that
Right.
and brainstorm about how we might want to edit it.
yeah, because that's where I get the most complaints about that part of it, like, I didn't know I could.
How difficult would it be for you to
Bring
send us a
things
sample?
or pictures
Or, that I can complain.
How difficult would it be for you to send us a sample of the official mailing that goes out to a neighbor?
It's incredibly easy. I can tell you just right now that the language that is in the agenda is the same exact language that is in the newspaper, mailed notice, and placard.
I think we're interested in the format,
Okay.
right? Like, how big is the piece of paper? How big is the writing? Is it 2-sided or 1-sided? Is it a standard size sheet of paper?
What else
like,
does it say besides the advertisement?
Okay, I will send
Whatever, even if it doesn't say.
an
anything,
example
just
of all
show
of
us
those.
exactly.
Yes.
Mrs. Freshman,
Even though it's after midnight and I'm trying to get out of here,
it's the 19th.
we had a conversation earlier that I think is important, and I just kept track. The first 2 items tonight were variances that were controversial.
Mm-hmm.
And even though there were no speakers, we spent almost 2 hours on them. And these folks, like the Montessori people who were here until midnight, is it possible that we put variances at the end? Do they have to come first? Do they have to be in numerical order according to the filings? Only because I think that's anything that looks like it's going to be remotely contested, even if it's not a staff denial, is something that I think it's unreasonable. We have to be here. All these people don't have to be here, and they have babysitters and get up at work the next day and all that stuff. And I was frustrated by the fact that it was 9 o'clock before we really started working.
Right. From a staff perspective, in the absence of a policy telling us to do it otherwise, I would be uncomfortable picking and choosing which cases go first. That said, you guys have full authority to A, set a policy, and B, to change the agenda at the very beginning of the hearing to hear which cases you want to hear first or later. But I'll leave it at that.
Okay, all right.
What, so you take them in the order in which they're...
The only exception is if there is a appeal, which we actually put first, though those are the longest cases you hear.
Right.
And I think that was a policy that started since I joined.
I don't...
I'd put them at the end, too.
I think it might have...
I'm serious.
I think past,
regular people need to go first.
We have taken appeals at various...
The county attorney doesn't want to stay.
Yeah, because they can leave. It hasn't always been that way. There have been occasions when they have stayed a long time.
I don't think that's a good excuse.
No.
No, I understand. I appreciate the information. I just don't.
Right.
I'm not sympathetic.
Here's another question. Is it ever appropriate to have a consent agenda?
It's hard.
Because we have to view each case on the merits, and we have to offer the public an opportunity to comment. We have to have a hearing on each case.
We could have a hearing on the full consent agenda. That would accomplish it. The problem is who gets to decide what is on the consent agenda.
Yeah, the non-controversial.
And I will tell you, in my view, the consent agenda has been created for the county board in living memory, and then further revised and revised and revised to reduce and reduce and reduce public input and public comment.
Mm-hmm.
And now it has been weaponized by staff to suppress public comment. So
I don't like that
eager
either.
to have a consent.
And I think of it like, I think of this like a court, if you will. And the courts, what they do in the morning, the judge will ask, does anyone have any motions? And those are the quick motions. And that's not a consent, but he'll do each one. And then he'll go to the docket.
So, Ms. Freshman, thank you for raising this point that we talked about individually.
It wasn't private, right?
No. Chances are we're not going to resolve it after 12:15
No, I get
tonight.
it, but let's think about it.
But I think we should have a conversation about it.
Yeah. I think really we should.
Conversations.
That's a part of our policies. We should really kick out the policies. And, there are 5 of us. We make it up.
Yep.
And then it will guide. Staff just said they want guidance via policy. That would be it.
Mr. Chairman, I move that we vote to approve the proposed notice to applicants regarding neighbor outreach as presented as version 1 of the neighbor outreach and authorize its promulgation to applicants.
Excellent.
Second.
And it's been moved by Mr. Owen, seconded by Ms. Freshman to promulgate as version 1 this notice to applicants. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
All opposed? The ayes have it. And
Move adjourned.
V1, and you know how they date them and put dates on the bottom, version 1. So you'll see to that. And it's funny. I looked at this. Motion to adjourn.
Thank you. It's been made by Ms. Freshman. We're looking for a second.
Seconded by Mr.
Thank
Owen.
you.
All in favor?
Aye.
Adjourning, signify by saying aye. Aye. All opposed? Ayes have it. We're adjourned.